Oh, wait. I think I'm live. I think I'm live. I think I'm live. Can you guys hear me? Can you hear me? Okay. So it was at the top of the StreamYard. It just kept saying streams and YouTube is having some kind of issue. It would not let me edit the time. It wouldn't let me edit the stream. And it wouldn't let me go live. It just kept saying at the top, like a banner that was scrolling across the top of StreamYard that was saying it was a known issue and that they had engineers working on the problem. I'm like, I ain't got time for you to mess up today. I have got Lemonhead to stream, right? Jeez, oh, Pete. Let me go back because it's been playing. They've been back from lunch for a few minutes. Hopefully it lets me stay on here. Let me share this screen. Okay. And I'm sharing straight from Judge Boyce's YouTube stream instead of through Law and Crime or anywhere else because I figure might as well stream straight from the actual source and not another party, right? Something like that.
That's the top of the stairwell, looking down towards the bottom of the stairwell. This part right here goes into the front room, and the front door is right here.
Okay, I forgot. The reason I don't like that. Let me see if it'll let me. It won't let me rewind this. It won't let me rewind it. That's why I don't like watching from here because for some reason he's got it set up to like automatically, like they're gone. Once they're played, they're gone. So let me go. Okay. I'm going to have to stop sharing and I'm going to have to go back to, I forgot that he does that. Dang it. All right, let me go back to let me go back to East Idaho. I'll go there because that's where Ween Baby said she had the best audio from. So let me do that. Present, share screen, live, share, make it big. And then I can rewind back from lunch to here. All right. Audio is up. Okay. Uh-oh. Didn't want to rehear myself. Stop it, Jenny. Stop it. Yeah, that's what I was going to say, QB. That's why I decided to go back to, because way he streams is I don't know what the actual setting is, but he's got it set so that you can't like rewind, pause, and then once the stream ends, That's it. They're done. They cut the whole thing. You can't like go back and watch it again. Rude. Okay, so now I think we have it fixed. Let me put it on 1.25. Put it on 1.25. And we will begin. We will begin. I need to send the new link out to you girls. Let me do that.
Thank you. Please be seated. Mr. Wood, before we proceed, is the statement be ready? Before any objections or anything to that?
Yes, if you would have a sidebar, that would issue, yeah, these issues about it. All right, we're on the record now. This is CR 22211623 State versus Chad Guy Daybell. The jurors are not present at this time. At a sidebar with counsel, previously a few of the exhibits that were offered and admitted had some reference material on them, base numbers, etc., from the case that the court raised a concern. And I believe, Mr. Wood, what you've done is figured out a way to remove those references from the exhibits, and the court would note those references were not published to the jurors, and they won't be, so the court will permit those references to be removed from the exhibits before they are published or provided to the jurors. Is that how we're going to handle that, Mr. Wood? Yes, that's my understanding, Your Honor.
All right, and is prior any objection from the defense to proceeding in that manner with those few exhibits?
No objection.
Okay, thank you. I'll make sure then that the original court exhibits to the jurors will have that information removed before the jurors are either published the information or receive copies of it. And with that, then I believe there are no other issues to take up before the jurors are brought in. Is the defense ready to proceed as well, Mr. Pryor?
Yes, Your Honor.
All right, thank you. Then we'll continue with testimony of this witness. And Mr. Wood, if you're ready, we'll have the jurors brought in.
Thank you. All rise. The jury is present and counsel.
Thank you. Please be seated. Included the lunch break at this time. We're continuing with testimony of Detective Hermosillo and Mr. Wood. If you're ready, you can inquire on the witness. You're still under oath for your testimony.
Thank you, Your Honor. Detective, before we were speaking about the search of a residence. Can you remind us what residence that was?
I believe it was apartment 175.
And whose residence was that?
Lord Dallas.
Your Honor, the state would ask that the witness be handed State's Exhibit 7A through 7K.
The witness is handed State's Exhibits 7A through K. They've been reviewed by defense. Mr. Wood, you can inquire.
Detective, do you recognize State's Exhibits 7A through K? Go ahead and take a minute and review them.
Yes, sir.
What do those exhibits look to be?
They are photographs that were taken of Lord Bell's residence in the morning of November 27th.
And were you present? You testified earlier you were present at the search of that apartment on that date, correct?
That's right.
Did you walk through every room in that apartment?
Yes, I did.
Did you take these pictures?
No, I didn't.
Do you recognize them as true and accurate representations of what you witnessed in that room that day?
Yes, I did.
Or, I'm sorry, in that apartment that day?
Yes, I did.
Your Honor, the state room for admission, State's Exhibits 7A through K.
The injection from the defense.
What urinated injection?
Yes, and these are my phone, please, Mr. Clark.
May I, Judge?
Yes,
Officer, what time were these pictures taken?
I don't know the exact time, roughly between 10 and noon, I would guess.
Are you guessing or do you know?
I don't know exactly what time, sir.
Okay, who took the pictures?
I don't know who took the pictures, sir.
What day did they take the pictures?
I believe I testified November 27th, 2019.
Well, if you weren't there, how do you know if you don't know who took it or who?
Objection is misstating the testimony.
no, I'll allow it. You can continue more than
I never once said I wasn't there. I was there the entire time on
That's not what my question was. The question was, you weren't there when the pictures were taken, were
I wasn't there when they were taking them.
you? You don't know the condition of the home when the pictures were taken, is that correct?
I was there when the pictures were taken, not standing next to the photographer.
So you were there when the pictures were taken,
That's right.
but yet you don't even know who the photographer was who took the pictures. Is that what you're telling me?
That's correct.
Is there a reason why you wouldn't know the photographer who's taking pictures for a police investigation that you're in charge of?
I wasn't standing next to the photographer. I was inside the residence when the photos were being taken. At the same time they were being taken, I wasn't standing next to him.
Okay, but the question I asked is why is it that you don't know the name of the photographer when this scene was closed off for investigation pursuant to a search warrant, and you can't tell me who the name of the photographer was who took these pictures?
There were a lot of people that were part of that search warrant. I can't tell you exactly who took photographs.
Well, that's what my concern is.
Prior, and we're getting speaking objections now. If there's a continuing objection, state the grounds.
Well, there were a number of people that were in and out of that apartment, is that right?
In and out of that apartment? No, sir. In that apartment, yes.
How many people were in the apartment at the same time?
Roughly 10.
And you would know all of the names of the people that were in the apartment, right?
Correct.
Yet you don't know the name of the photographer who took the pictures. Is that what you're telling me?
That's what I'm telling you, yes, sir.
Should I object?
Your Honor, I'm gonna lay some more foundation.
All right, you can lay additional foundation, and I'll also note it is a group of photographs, so if you work through them individually, we will. I'll note just an objection on 7, 8, K, and this way you can seek additional foundation related before I rule on the objection.
Executive, you testified you were present that day,
That's correct.
and you recognize these images as true and accurate representations of what you saw in that apartment.
That's correct.
And is it a true and accurate representation of the condition you found the apartment in?
Yes, sir.
And as you look through these pictures, is there anything in there that is different than the way you found it?
No.
Your Honor, statement was again for the admission.
Objection, again, Judge, there isn't a proper foundation. The officer can't even tell me who took the pictures. He doesn't know what time the pictures were taken. And the condition he's talking about is the condition he saw, not necessarily when the pictures, in the condition when the pictures were taken. So there hasn't been proper foundation here.
All right, I've considered the objection. I'm going to overrule the objection as it relates to photographs when the officer has personal observation of the location. The one exception that I'll consider a standing objection on is on 7G, which is different, I would say, than just showing the apartment. Not saying it's not admitted, but still under advisement, pending additional objection on the foundation. So photographs with the exception of 7G are admitted, and you can require further history work.
Thank you, Your Honor. If I could publish those to the jury.
Yes.
Second, can you tell me what you observed in State's Exhibit 7A?
That's the front door of apartment 175, front porch area.
And is this the apartment that you searched when you were for JJ?
Yes.
Second, what did you observe in State's Exhibit 7B?
So as you walk into the front room of the apartment, that's looking towards the dining kitchen room area. There's the child's car suitcase sitting there. Like I testified earlier, it looked like it was lived in. There's still chops, things on the counter, paper towels, everything looked normal.
What did you observe in State's Exhibit 7C?
That's standing in the kitchen, facing the doorway, so the opposite direction of the last photograph. You can see the stairwell going upstairs. There's still pictures on the wall, TV, papers on the counter. Everything looked normal at that point, so.
Observed in State's Exhibit 7D.
So when I testified about the crawl space under the stairs and the 72-hour kits, those are a few of the 72-hour kits, along with the stove suitcase that we had located.
When you, Your Honor, does the court have a pointer?
So
I don't know, let's have the bailiff run that. No, we do not. So.
Can you point to what you're referring to describe the 72-hour kit?
So these black bags,
Mr. Wood,
Yeah.
okay, go ahead.
these black bags with 72-hour kits, there's some underneath here that you can't see. There's some here, and then that's the stove suitcase that I was referring to earlier.
Detective, what did you observe in State's Exhibit 7E?
That's the top of the stairwell looking down towards the bottom of the stairwell. This part right here goes into the front room, and then the front door is right here.
What did you observe in State's Exhibit 7F?
This is the master bedroom. So when you come up the stairwell, immediately to your left is this entrance here. Like I testified, there was bedding, pillows, everything looked normal in the room at that point. This is a bathroom as well.
Hey, guys, just a quick heads up. In the chat, there should be a poll. I just made a new poll. And the poll, let me just kind of explain so you know where I was going with it. They only allow you so many characters in those answers in the question part. But I think the question I asked was, do you think that Chad and Lori believed in their faith/religion? And I put yes, 100% believed in it. And the other option was no, they were lying to their family and friends, basically in a roundabout way of saying that they didn't believe the crap that they were spewing from their mouth, that they were just trying to get people to drink their Kool-Aid, right? For money and power, so to speak. And then 3, not sure. So there you go.
What did you observe in State's Exhibit 7H?
7H is what caused some red flags for us when we were searching the apartment.
Why was that?
Because of all these empty hangers. People go on trips.
Judge, I'm going to object as unresponsive. There isn't a question here. That's a narrative.
Sustained. The fact that I asked you why the empty closet was concerning to you.
Because when we made contact with Lori Vallow the day before, she had lived in the apartment. She was in the apartment living. The very next morning, when we served the warrant, this is what we found, empty hangers.
And why would empty hangers be concerning to you?
Because it appeared to us that she grabbed her clothes, left everything else, and took off.
What did you observe in State's Exhibit 7I?
This was a bedroom. If you walk down the hall towards the west, this is the bedroom on the right-hand side. This is the bedroom we found some of Alex Cox's belongings in. So this is the bedroom to the right.
And what belongings of his did you find there?
There was a plastic tub with some of his belongings in, some hygiene things that had his name on it, things like that.
And what did you observe in State's Exhibit 7J?
This is the same bedroom. There's one of the plastic tubs that had some belongings of Alex. There's some prescription pills up here that had Alex's name on them. And then there was some white tie-dye suits that were in the closet area.
What did you observe in State's Exhibit 7K?
This is the room to the left. So the previous room was to the right. This is the room to the left. It had twin beds, bedding, everything looked normal in that room as well.
Your Honor, I'm going to ask that the witness be handed State's Exhibit 7G again for further foundation. Very well. That's if you recognize State's Exhibit 7G.
Yes, I do.
What does it report to be?
A rental agreement with the tenant of Lori Ryan.
And you testified earlier about finding the rental agreement. Is that correct?
That's correct.
Is this the rental agreement that you were speaking about?
Yes, it is.
And where was that located in the residence?
in the master bedroom on a desk in the corner.
And you saw it there?
That's correct.
And is that a true and accurate representation of the rental agreement you saw?
Yes, it is.
Your Honor, I move for admission of State's Exhibit G, 7G.
Any objection?
No, Judge.
All right, exhibit 7G is admitted as well.
May I publish?
Yes.
Second, is this the rental agreement we were just speaking of?
Yes, it is.
And you testified earlier about searching the storage unit, correct?
Correct.
Was this the rental agreement that led you to that storage unit?
Yes.
Thank you. Your Honor, I'd ask that the witness be handed what's been marked as State's Exhibit 8A through 8Q.
Wow, they were on a big break. I figured that they would just start talking any second, but nope. No. Finally. Finally. Hey Tammy, did I say hi to Tammy? Lauren, hey, hey. Kel said the yard is getting blown, so
Second, I'm going to ask you to take a moment and review State's Exhibit 8A through 8M.
yes, Margaret, still the detective. Yep. I know it's hard to see. But yeah, Detective Ray Hermosillo.
Photographs taken.
November 27th, 2019. Photographs that we had taken in number 175 in the garage.
And what day were these photographs taken?
November 27th, 2019.
And was this a part of the search that you testified to earlier?
Yes,
And you were present in the garage?
that's correct.
Were these items laid out in this manner when you got to the garage?
No,
Were they taken out to be photographed?
yes,
And did you observe that taking place?
I did.
And other than moving those items to be photographed, are these pictures, are these items in the same condition that you observed them that day?
Yes, in the same condition, like I testified to, we manipulated some of them so we get better photographs.
And are they true and accurate representations of what you observed in the garage of that apartment that day?
Yes.
Your Honor, the state would move for admission of State's Exhibit 8A through 8M.
Or dealing with.
I'm sorry. I should have said 8L.
Any objection as it relates to 8A through L?
Judge, what are your any objections?
Very well.
Officer, as before, were you present when the pictures were taken?
Yes.
What was the name of the person who took the pictures?
Detective Daybell.
Were you present at the exact time the pictures were taken of all of these items?
Yes, I was.
Who else was present at the time that these pictures were taken?
I couldn't tell you what else was in the room.
Well, we were in a garage, aren't we?
Couldn't tell you what else was in the garage.
Were there so many people there that you don't know?
No,
Your Honor, this doesn't go to foundation.
I'll allow them more dire if you wish, Mr. Pryor, continue.
So many people in the garage, you know who was there?
I just can't recall their names at this.
They're not officers that work with you?
They are.
How big of a garage are we talking about?
I couldn't testify to that.
2-car garage, 1-car garage?
As far as we're getting costs here, is this a foundation objection still?
Judge, I'm trying to establish. Judge, I'll move on. Say it.
All right, the court's considered foundation objection as it relates to exhibits A through L. I'll overrule the objection and those may be admitted.
Thank you, Matt Publish.
Yes.
Detective, what did you observe in the State's Exhibit 8A?
So when I testified earlier about various magazines, weapons, there were knives, this is where we found those items. And
I
this,
just want to stop you real quick to clarify. When you say magazines, what type of magazine are you referring to?
magazines that were like those.
And you testified that you moved these items to take pictures of.
Correct.
And what did you observe in the State's Exhibit 8A?
So here's some of the various magazines that we took out of some of the tubs. There's some ammunition. There's a few suppressors that screw on to the end of a gun to muffle the sound. There's a ghillie suit. Different items in this photo. Different spots.
Could you tell me what you observed in the State's Exhibit 8B?
So these were items that were located in black plastic bags, which are right here that I'm pointing to. So we simply took those items out of these plastic bags and laid them out so we get photographs of them.
What did you observe in State's Exhibit 8C?
These are various caliber ammunition in plastic bags that were located in plastic cups.
When you say ammunition, those are for bullets, correct?
Correct.
What did you observe in State's Exhibit 8D?
This was one of the rifles that we had located in the garage in apartment 175. It's got that tape here. What you can't see up top.
Judge, I'm responsive.
This day. I'm gonna move the picture so you can see the top. What did you observe at the top of State's Exhibit 8D?
Like I was testifying to, at the top of this rifle, it's threaded for a suppressor to muffle the sound of a gunshot.
What did you observe in State's Exhibit 8E?
This rifle here is the exact same rifle from the previous picture. There's also another rifle that was in the bag, and that's this one here. This photograph was taken at the police department once we got the items back.
What did you observe in State's Exhibit 8F?
This is the rifle in the previous picture that was back here. It's just a close-up of that rifle.
What did you observe in State's Exhibit 8G?
Those are what I call the suppressors. Earlier, there was a photograph of these two on the garage floor. This is just a close-up of both of those suppressors.
What did you observe in State's Exhibit 8H?
These are knives that were found amongst the ammunition in the rifles and tubs.
You described to the jury what you observed in State's Exhibit 8I.
This is just a handgun that was also located that was still in the case inside the garage.
Did you observe in State's Exhibit 8J?
This is a Halloween mask, or what we think is a Halloween mask, that was located in a plastic bag in the garage along with duct tape and rope.
You described to the jury what you observed in State's Exhibit 8K.
Once we remove the Halloween mask, this is the duct tape and the rope I was referring to in a Walmart bag.
And what did you observe in State's Exhibit 8L?
That is a passport that was located in belongings in that garage belonging to Alex Cox.
And Your Honor, I'd ask the witness be handed State's Exhibit 8M through 8Q. Very well.
Is anybody able to make any sense of anything off of the screen projector thing? Because I cannot.
Briefly review State's Exhibit 8M through 8Q.
Okay.
Do you recognize those exhibits?
Yes, I do.
What do they purport to be?
These are items also located in the garage 175.
Not yet. Did you observe these items with your eyes?
Yes, I did.
And you saw these on November 27th during your search at apartment 175?
Correct.
I believe you testified they were also in the garage.
That's correct.
Are these true and accurate representations of what you observed that day?
Yes.
Your Honor, I move for the admission of State's Exhibit 8M through 8Q. Any objection?
Yes, it's one of your native objection, Judge.
Go ahead.
Officer, we previously testified that you, I don't want to put words in your mouth, but you staged certain items. Is that a fair assessment?
Correct.
And some of the items that you staged, when I mean staged, you remove those from packages or boxes, and you laid them out to take pictures. Is that correct?
That's correct.
Did you take pictures of all the items in the garage, or are these just selected pictures that you've decided to show today?
We took photographs of the items in the garage, anything that we thought was evidentiary value. We took photographs.
Okay, so the question is, or excuse me, the answer is then that you did not take pictures of everything that was in the garage. Is that fair?
No objection, Your Honor. This is cross, not doesn't put a foundation of these items.
I do sustain that. We need to get a narrow issue of foundation for admission or not, and we need to be allowed to costs later, of course. Somebody, you have any other questions on that?
So the question is that when I hear previously that you took items out of a package and you took pictures of select items, did you take all of these items out of some sort of packaging and take select pictures of these as well?
Yes, we took these out of tubs that were in the garage to close it.
So when you were there and present going through the garage, and we don't know how big this garage is because you don't know. You couldn't see these in plain sight when you went through them, correct?
That's correct.
So you don't know what was in the garage and what wasn't. These were staged by someone else who took pictures, is that correct?
We took these out of tubs and took photographs of them.
Who took them out of the tubs?
I couldn't tell you what officer took them out of tubs.
When did they take them out of the tubs?
Are you asking for a time, sir?
I'm asking for a time, yeah.
Roughly 10 to 12, I would say.
In the afternoon, in the morning, when
10 o'clock in the morning. Till 12 noon.
and you were present when they were taking these out of the tubs?
That's correct.
And who took these pictures of us?
Detective Hope.
Judge, I have nothing else. Thank you.
All right, I'll rule an objection on foundation relating to exhibits 8M through Q, and those will be made.
Thank you. May I have a question?
You know,
Detective, can you describe the jury what you observed in State's Exhibit 8M?
That is what appears to be an email printed item that was located in the garage at 175. There's some handwritten scribbles on it, some names, numbers associated with those names.
And at the time that you found those documents, did you understand what that?
No,
Were you able to determine, you said it was an email, who the sender of the email was?
yes,
Who was it?
Shadow.
Were you able to determine who the recipient of the email was?
I don't recall the recipient. Just
No.
who sent it.
Oh, I apologize, I didn't get that down.
I just remember who sent the email.
And you were able to tell what date it was sent?
I believe it was October of 2018.
Was there a specific date?
I would have to look at it a little closer. It's in the upper left-hand corner.
Second, I'm going to have State's Exhibit 8M, if you can describe what you observed there for the jury.
That's the same photograph from the last slide.
And State's Exhibit 8 vote. Or is you vote?
That's also more the same email papers from the last slide.
Detective, if I were to have State's Exhibit 8 and attached, would you be able to tell the date of the email?
Yes.
What is the date on that email?
October 30th, 2018.
And then detective, what did you observe in State's Exhibit 8P?
Those were also in the tub books written by Chad Daybell.
And then lastly, what did you observe in State's Exhibit 8Q?
That was a cell phone that was also found in the tub in the garage.
Were you able to look and get that cell phone at any time?
As far as forensically,
Yes.
I wouldn't be able to tell you unless I looked at the report.
Detective, we've been talking about this search on November 27th, correct?
Correct.
And at any time that day, did you locate JJ Vallow?
No.
What was the next step in your investigation to find JJ?
Our next step was to talk to him.
Oh my gosh, Gail, I am so sorry. I saw what you said and I was like, wait a minute. And I went over there and looked and I saw there was two with the same exact identical titles and everything. I don't know what happened. I think because there was some sort of a glitch with StreamYard earlier and it wouldn't let me go live. So that there was some sort of like a StreamYard site-wide outage or something, and that they were working on the issue. So I didn't realize that there were two identical ones up. And I went and looked and I was like, oh my God, there was another one. So I don't know what happened. I don't know if I accidentally started another one or what. So yeah. Yeah, I don't know. I don't know. I do not know. I'm glad that you found us. I'm glad you found us. Eee.
Anybody that would take our phone calls. JJ was,
Judge, I'm going to object. This is again between a narrative.
You're already still just answering the basic question.
I'll rule that objection.
JJ was who we were looking for. And so we were exhausting every effort to find JJ. So we would call his siblings, family members, any family friends, anybody that might know whereabouts of JJ.
So who were some of those family members that you spoke with?
We ended up speaking with Brandon Boudreaux, Melanie Boudreaux, JJ's brother, Colby Ryan. Gilbert Police ended up speaking with family members down there. That's who we spoke.
At any time during your investigation, did the scope of the search change to who you were looking for?
It did.
Why was that?
After we spoke with Colby Ryan, who was JJ's brother, he mentioned that he
Judge,
had,
I'm going to object. This is hearsay.
Sustained. Detective, at any time did the scope of your search change to include the search for Tylee Ryan?
it did.
And so let's go back to your search very briefly on November 27th. Did you see Tylee Ryan at that apartment at any time?
No,
And during your intermittent surveillance you talked about in early November, had you seen Tylee Ryan?
no,
Did you ever meet Tylee Ryan?
no,
Did you become familiar with who she was through your investigation?
yes, we did.
How did you do that?
After speaking with Colby, our search encompassed JJ and Tylee.
You know, I'm going to ask the witness behind it states exhibit 5. I believe this runs by stipulation.
It does. Judge, we've stipulated the admission from this exhibit. The counsel will be so kind as to repeat the exhibit number for me, please.
5.
All right, exhibit 5 has been offered and admitted. You can proceed, Mr. Wood.
Thank you. Detective, do you recognize exhibit 5?
Yes, I do.
What is it?
It's a birth certificate issued out of the state of Texas.
Your Honor, I published that for the jury.
No objection.
Well,
Were you able to read that on the screen?
Yes,
You could point out with the name of the individual or who that birth certificate applies.
the name is Tylee Ashley Ryan.
And what was the date of her birth?
September 24th, 2002,
And where was she?
Travis County, Texas.
And just for purposes of the record, can you state who her father was?
Joseph Anthony Ryan Jr.,
And who was her mother?
Lori Noreen Cox.
Through your investigation, have you learned of Lori Vallow's maiden name?
Yes,
What was it? Okay. So Detective, you testified that at this point you were approximately when did the scope of your search widen to include Tylee Ryan?
It was after we spoke with Colby, on December 11th, 2019, we entered JJ Vallow and Tylee Ryan into what we call NCMEC, which is the National Center for Missing and Exploited Children. So on December 11th, 2019, we entered both of those children as missing and endangered.
How does NCMEC work?
It's a center where
I'm going to object at this point on foundation.
Mr. Rose, if there's any additional foundation or anything that has been.
Okay. Can you restate again what the acronym NCMEC stands for?
National Center for Missing and Exploited Children.
And is that associated with a government entity?
It is.
Do you know which entity?
Uh,
Have you ever used NCMEC before in your job as a detective?
yes.
How have you used it before?
When we have missing children, we enter and call NCMEC, enter the information that goes into the database.
Mr. Wood, for the record, could you indicate that?
Yes, Your Honor, it's NCMEC. Thank you. If you'd like the detective, can you just state what that stands for again?
National Center for Missing and Exploited Children.
Did you include any other law enforcement agencies in this search?
We did. After November 27th, we reached out for assistance from the FBI. We reached out through Fremont County. So we were in contact with Gilbert Police, Chandler Police, anywhere down there where JJ or Tylee lived or could possibly be at.
And did you ever try to contact Vallow Daybell in regards to the whereabouts for children?
Absolutely.
How did you do that?
We tried contacting Lori by her cell phone. We also attempted to contact,
So let's talk about that real quick. Were you able to talk to her?
no, her cell phone was shut off.
Did you ever attempt to contact Chad Daybell in regards to the location of the children?
Yes, we did.
How did you do that?
We attempted to contact him through his cell phone.
And were you able to get in touch with him?
No, it was also shut off.
And at any time, did Lori Vallow ever call the Rexford police to report some children?
Judge, objection. Foundation.
Response, Mr. Wood?
Your Honor, it's just a basic question. I think it's in line with the question we've been going through. I don't know what additional foundation.
Foundation is overruled. What is the answer?
Did you ask that again, please?
Did Lori Vallow ever contact the Rexford police, to your knowledge, regarding missing children?
No, she didn't.
Did Chad Daybell ever contact the Rexford police regarding missing children?
I'll renew my objection, Judge. Knowledge, foundation.
It's overruled.
No, he didn't.
Detective, when you place the children in the NCMEC database, do you receive tips from that?
Yes, we set up tip hotlines through NCMEC, also through the FBI and through the Rexford Police Department. So anybody with any information on those two missing children could call any one of those numbers and provide us with any information.
And did you ever receive tips through NCMEC regarding JJ Vallow, Tylee Ryan?
Yes, we did.
What would you do when you received those tips?
When we would receive the tips, we would assign it a tip number. And those tips were followed up on by detectives or other officers. So as soon as those tips came in, they would give a number and assigned to an officer that they would follow.
And would those tips, when they come in, do they have a phone number associated with that?
A lot of times they did have a phone number. A lot of them were anonymous. They didn't want to get involved. So some of them had phone numbers where we could follow up, others didn't.
And if someone submits an anonymous tip through NCMEC, is there anything you can do to follow up on that?
It depends on the information they gave us, but we would follow up with any information that they had put on the tip.
And when a tip comes in with a phone number, would you call those individuals back?
Yes.
Did you ever alert the public that the children were missing?
We did. We held a press conference on November 20th, 2019. And alerted the public that we had 2 missing children in our yard.
And after that press release came out, did you receive tips after that?
Yes, we did.
And did you follow up on those tips as well?
Yes, we did.
Did any of those tips ever lead you to finding JJ Vallow?
No,
Did any of those tips lead you to finding Tylee Ryan?
no.
Detective, regarding Tylee Ryan and JJ Vallow, are you aware if a child protection action was filed in Madison County?
Yes, it was.
Were you involved with that?
I was the one who wrote the affidavit.
And what was the purpose of that action?
Judge, I'm sorry, I didn't hear what the officer's response is. I was the one who wrote the,
Wrote the affidavit.
And what was the purpose of that action?
Judge, I'm sorry, I didn't hear what the officer's response is. I was the one who wrote the affidavit. Thank you.
You want to ask your questions?
I will, I just letting the witness.
Holy shit.
Detective, what was the purpose of that affidavit?
To get Lori to produce her children to the Rexburg Police Department or the Department of Health.
And are you aware if there was an order issued in that child protection action?
There was.
What did it order?
It ordered Lori Vallow to produce her children within 5 days of being served at court order.
Detective, were you ever able to locate Chad Daybell and Lori Vallow?
Yes, we were.
How did you do that?
A few different ways. Some of the tips that came in gave us location in Kauai, also through cell phone data.
Judge, can I have some foundation as to the time, date, location?
Are there foundational objections?
I'll just ask some more questions, Your Honor. So, approximately when did you learn about the location of Chad and Lori?
Beginning of January of 2020.
And you said it earlier, but what kind of tips gave you that information?
Eyewitnesses that would call in that said they saw Lori and Chad on the island of Kauai,
And where is Hawaii?
in Hawaii.
Did you ever write warrants to aid or apply for warrants to aid you in finding Chad and Lori?
Yes.
What kind of warrants were those?
We wrote warrants for cell phone data, geofence location, a few different warrants through cell phone companies to assist us in finding Chad and Lori or their location.
And did any of the data you received from those help you locate them?
Yes, it did.
Jacob, did you ever go to Kauai as part of your investigation?
Yes, I did.
And what did you do when did you get there?
I got to Kauai January 24th, 2020.
And once you got there, what was the purpose of going there?
We went there to aid and assist the Kauai Police Department in serving that court order to produce JJ Tylee to the Rexburg Police Department.
And did you see Chad and Lori Daybell in Kauai?
Yes, we did.
You mentioned assisting the Kauai Police Department in serving that order. Are you aware if Lori Vallow was served with that order?
Yes, she was on January 5th, 2019. Correction, 2020.
While you were in Kauai, did you do anything else?
We observed the Kauai Police Department serve 2 search warrants. One on Chad and Lori's condo and the other on the rental vehicle.
Did you perform those searches as well, or just observe the Kauai Police Department do it?
No, we just observed and let them serve.
Do you recall where their condominium was located in Kauai?
I don't recall the physical address, but it was Princeville.
And is that a town or city in Kauai?
Yes.
When you observed the search of the residents they were living in Princeville, after the Kauai Police Department did their search, were you able to walk through that residence?
Yes, I was.
What did you observe at that residence?
Everything looked normal. It appeared 2 adults were living there. There were beach towels, 2 beach towels, everything was in pairs. Food in the fridge, couches, everything seemed ordinary.
Did you see JJ Vallow there?
No,
Did you see Tylee Ryan there?
no,
Did you see anything that would have indicated to you that a child was living there?
no, I didn't.
Did you observe anything that would have indicated to you that a teenager was living there?
No.
Detective, to your knowledge, did Lori Vallow ever produce her children to the Rexburg Police Department or the Department of Health and Welfare?
No, she didn't.
Your Honor, I'm going to ask that the witness be handed State's Exhibit 6. Detective, do you recognize State's Exhibit 6?
Yes, I do.
What does it purport to be?
It's a photograph of Tylee Ryan.
Did you, as part of your search, did you look at Tylee Ryan's social media?
Yes, we did.
To your knowledge, was this image obtained from her social media?
It was taken from her Instagram account.
And so as part of your search, did you personally observe her Instagram account?
Yes, I did.
And did you personally observe this image on her Instagram?
Yes, I did.
Is this a true and accurate representation of what you observed on her Instagram?
Yes.
And also, as part of your investigation, did you see other pictures of Tylee Ryan?
Yes, I did.
And is this individual, is that true and accurate representation of Tylee Ryan?
Yes.
Your Honor, the state would move for State's Exhibit 6 to be entered into evidence.
No objection, Judge.
Very well. Exhibit 6 has been offered and admitted without objection, so it's in the record and will be published if you wish to support.
Thank you. Detective, is this the exhibit we were just speaking of?
Yes, it is.
What was the username on the account that you found that picture in?
Tylee A. Ryan.
And this individual is the Tylee Ryan that you came to recognize through your search.
That's correct.
Detective, I want to ask you about the phrase proof of life. Are you familiar with that phrase?
Right.
As a detective, what does that mean to you?
Proof of life is any documentation, any video, photograph, anything we can use to show the last time somebody was saw alive or seen alive.
Pursuant to your investigation, did you find a last known proof of life for Tylee Ryan?
Yes, I did.
How did you locate that?
That was taken from Lori Vallow's iCloud account.
And what, do you know which iCloud account it was taken from?
Lori for style at iCloud.com.
And then what was the form of that proof of life?
It was a photograph of Tylee taken at West Hills.
Your Honor, I'm going to ask the state or the witness to hand State's Exhibit 29A, 29B, and 13. And I believe these are made by way of stipulation.
All right. Defense attorney as well.
Judge, that's correct, by way of stipulation.
I'll just review those briefly and then have a quick sidebar with counsel.
Sure.
be submitted to the witness. And I will note that exhibits 29A and B and exhibit 13 are all admitted without objection. You can proceed, Mr. Williams.
Thank you. Detective, would you look at State's Exhibit 13? What is that for?
That is the photograph taken from Warrior Styles, high-copy. They testified to and with Tylee and Miss Yellows.
If I'm in publishing.
Yes.
You can just identify the individuals in that photograph. Detective.
Sure. The little boy is JJ Vallow. The Tylee Ryan's in the middle, and their uncle Alex Cox is on the right.
And as part of this exhibit, did it contain metadata?
Yes, it did.
And does the metadata in this is, well, can you describe the jury what metadata is?
Sure. Metadata is like a time and date, is a time and date stamp with the photograph that's taken. So it's just data associated with the photograph.
And this photo was accompanied by metadata.
That's correct.
And what date was this photograph taken?
September 8th, 2019 at 2:49 p.m.
And you testified earlier that this was in Yellowstone.
Yes,
How do you know that that's Yellowstone?
I've been there.
So you personally recognize that location?
Sure.
Detective, revisiting this idea of proof of life. Throughout your investigation, were you ever able to find photographs dated later than that of Tylee Ryan living?
No.
And can you describe just quickly where you found that photograph?
From the iCloud account associated with Wardell.
And I believe you already said it, but just for purposes of the record, what was the name of that account?
Lori for Style at iCloud.com.
And how do you know that that account was associated with Wardell?
The information attached to it and also the photographs that were attached.
And when you say photographs, what type of photographs led you to believe that that was attached to Wardell?
Family photographs, Lori Vallow's photographs with her in the photos.
Detective, pursuant to your investigation, are you aware of a last known proof of life of JJ Vallow?
Yes, I am.
Your Honor, ask this, the witness behind states exhibit 14, which I believe also comes in by way of stipulation.
From our record, then, Mr. Wood, it's been stipulated to, and we'll give it for this. Is there an objection to the 14 minute,
No, Judge, it was entered by stipulation of parties.
or 14 is admitted?
Detective, what is states exhibit 14?
That is a photograph of JJ sitting on a couch in what appears to be the front room of apartment 175.
And where did you locate this picture?
That was also on Lori for Style, iCloud.com.
And you mentioned you believe you recognize the location. I'm sorry, can you say that again?
Yes, it appears to be the front room, same type of couch that was found in Wardell's apartment 175.
And did this picture have, well, may I publish a picture? Anyone? Can you just describe the jury what you observed in states exhibit 14?
That's JJ Vallow sitting on the couch in red pajamas.
And did this picture, was this picture accompanied by metadata?
It was.
Is this the metadata that accompanied that picture?
Yes.
Can you What was the date of that picture?
September 22nd, 2019,
Do you know what kind of day it was taken?
11:46 a.m.
And just to clarify, what iCloud account was that picture taken from?
Also, Lori for style. I thought that.
So Detective, you testified earlier that, an order was served on Lori Vallow to produce her children.
Correct.
And I believe you already testified that she did not produce her children.
Correct.
What was the next step in your investigation after that?
Our next step in that investigation was to reach out to anybody that would possibly know where JJ was.
Who would you reach out to?
We reached out to family, the FBI, other agencies, anybody that would take our calls, tips that were coming in.
Detective, while you were doing this investigation, were you aware of any investigation in Fremont County regarding Tammy Daybell?
Yes,
And what did you know? Were you a part of that investigation?
I was a part of it, but my focus was mainly JJ and Tylee.
And what was the investigation in Fremont County regarding?
A suspicious death involving the defendant Daybell's wife.
And as part of your investigation, did you know when she had died?
Yes,
When was that?
October 19th of 2019.
You testified that your primary focus was locating Tylee and JJ, correct?
That's right.
Your Honor, please have a very brief sidebar.
Yes.
To make every effort to be concluding trial each day at 3:30, including today. We are going to take our mid-afternoon break at this time. And just for your reference as well, in case I forget to mention, we'll be going through evidence and testimony again tomorrow, scheduled 8:30 to 3:30. And then with some scheduling issues, we are going to not be holding court on Friday. And so we'll be back on Monday. I just want to make you aware of that schedule as well. So we'll go until 3:30 today, but at this time, we will take our break, so we can try to keep the break to 20 minutes. I appreciate it. With that, I'll apologize for the jury.
Sorry, catching up in the chat. Hey, Miss King of Anything. Hi, hi, hi. Yeah, Sidebar City. Margaret, I agree. Do we really need the screen up there for the judge? Wait, I'm confused. Crappy quality, they end early today, and nothing on Friday. Yeah, no wonder it's going to take 10 weeks. Right? Okay, hold on just a second. I'll be right back, guys. Give me a couple seconds. Okay, sorry about that. I'm back. Had to do something for the child. Let me see. What was it Patricia said? When is Koberger hearing? Today. Who was it? Was it Ween Baby that came in here earlier today, or was it Steph? Maybe it was Steph that came in here today and said earlier this morning that Koberger's hearing is today at 7 p.m., 4 p.m. West Coast time, which is 7 p.m. Eastern Standard Time. Yeah. Yep. Which sucks. Right? Well, I guess it is what it is, right? Let me click the live button and see, because we were a couple minutes behind. But now we are caught up. Sure thing, Patricia. No worries. No worries. They're just taking their little afternoon break. And Yeah, they're taking their afternoon break. I don't understand though why they are not going to have court on Friday. They said, didn't they say something about like scheduling issues or something like that? I'm not positive. I'm not positive. Oh, I don't think it's done. I thought that they said that they were taking their afternoon break, but they would be going till 3:30 today, which is 5:30 our time. Am I wrong? Did I miss that? Did I hear wrong? Okay, that's what I thought, QB. Spins made me sweat for a minute. I was like, really? Are you serious with me right now? Because what I heard him say, what I know, the crappy audio is horrific. I really do hope that that the judge gets the hint. I really don't think he cares, but also maybe he'll be nice and let the media come in and use their equipment because their webcam sucks. Yes, QB, that's what I'm thinking. 10 weeks of this. Ugh. And the exhibits, like showing the screen, they have that third camera up there, right? With the witness and the screen on the wall. That is useless to people viewing. Useless. Right, Patricia. Even the lawyers can't hear the witnesses. Right. They might as well just take that camera down. Right. It's not doing them any favors. And really, we don't need to see Judge Boyce. Love you, Judge Boyce, but I don't have to look at you. I'd rather look at the prosecution, the defense table, the witness stand with the screen behind them. Yes. Poppy is scratching at the door. Between Poppy and the kiddo, they're wearing me out. I don't understand, Tammy. I don't know why. I mean, you would think that I don't know if it's because he wants to have control of what's viewed. But it's streaming on all the networks. So why not just let the media camera come in and let them do what they're good at. Right? Let the camera guys come in and the audio guys come in and do what they're good at and just let them do it. It's ridiculous. Close-ups would be appreciated. Absolutely. Right, QB. That's the only thing, but here's the thing. If he's going to with them having control, he can shut it off and it's shut off when he wants it shut off, right? He has control of that. And then also there's no chance that that the jury will accidentally be shown. So I don't know. Hold on a second. I have to let my doggo in. Yeah, rain, rain, go away. Yep, he's the judge. He can tell him to shut it down. Yeah, that has happened quite a few times. But I've also seen QB where the judge literally calls the juror by name instead of number. Not very smart. Not very smart. Friday, though, if they're not going to have court on Friday, what should we do on Friday? What should we do on Friday? Margaret said, I was juror number 10. Wow. QB's like, ma'am, you just read my mind. Well, what are we going to do? What are we going to do on Friday? What will we do? Ooh, ice cream social? QB was playing with polls on Discord. Oof. Ooh, Spin says cafe part of Crime Cafe all day. Oh. We'll have to come up with something. Maybe I'll start a poll. We'll have a poll of something to do on Friday. Oh, Spence said she'd even come up and say hello. Hello. Party. Party. That might be kind of cool. We need to come up with a game that we can play, like I don't know, some kind of, what do you want to call, like a murder mystery. A murder mystery type of game. Or Clue. Some kind of a virtual way to play, I think would be kind of cute. Spins, you are super cool. Super cool, super cool, super cool, super cool, super cool. Hmm. Oh, okay. Well, QB, if you're going to play that game, ma'am, QB says, now you got to say something nice about yourself. What? Because I'm assuming because she said something bad about herself. So, ma'am, I'm calling you out, QB. You say bad stuff about yourself all the time. So let me hear you say something good about you. Mm-hmm. Oh, you're cool. See, now why can't they do that? But not.
Thank you. Please be seated. We've got the jurors returned.
Yes, Your Honor.
Council, while we're waiting for the jurors, we will take up on the record at the conclusion of today, after the jurors can dismiss, the issue of further stipulated exhibits, and I'll bring that up before we conclude for the day.
See how it was when they first came up? It was just the judge's screen, the judge's camera. So what they should do is just have one camera, but go back and forth between them, like the other media cameras. They do that. They have it set so that when the judge is talking, you see just the judge. When the witness is talking, you see just the witness. When the lawyers are talking, you see just the lawyers. That's what they should do. Let me come over there and be your camera person, Judge Boyce. I can do that. Let me do that.
All rise.
Ooh, Margaret says I can step up and tell lemon jokes on Friday. Mm-hmm. Right, Margaret? I know what you mean. Mhm.
Jury is present and accounted for.
Very well. Please be seated. All right, we're back on the record after our mid-afternoon break. Mr. Wood, if you'd like to continue the examination of the witness, and I'll remind the witness, of course, you're still under oath. Mr. Wood.
Thank you. And I need to just take up a couple of issues for clarification of the record. Detective, you spoke earlier about searching Lori Vallow's residence.
Correct.
And yeah, you stated the address. What city was that address located in?
Rexford.
And what state is Rexford in?
Oh, yeah.
Thank you. Detective, as part of your investigation, did you ever help execute a search warrant on Chad Daybell's residence?
I did. I executed a couple of warrants.
Okay. When was the first one?
January 3rd of 2020.
And Chad Daybell's residence, what county is that located?
Madison County.
What's his address?
202 North, 1900 East.
And is that, and what city is it listed as?
It's listed as Rexburg. It's actually in Fremont County, but it's listed there.
Okay, so just to be clear, did you just misspeak when you said it was in that
I
city?
did. I'm going to say it directly.
Okay, and it's what county?
Fremont County.
All right, thank you. And you testified that you did a search there on January 3rd.
Correct.
Was that search in aid of another investigative agency?
It was
Which agency was that?
Fremont County Sheriff's Office.
And do you recall what the purpose of that search was for?
I don't recall what the probable cause or the reason for the search was at that time.
So you didn't write the affidavit.
So,
Did you have any other occasion where you served a search warrant on Chad Daybell's residence?
yes, June 9th, 2020.
When you served that warrant on June 9th, 2020, what time did you arrive at Chad Daybell's residence?
Roughly about 7 in the morning.
Your Honor, I'm going to ask that the witness be handed State's Exhibit 10A.
I tried all the different streams, Wheaton Baby, and I didn't find anything that was any better.
Detective, are you familiar with State's Exhibit 10A?
Yes, I am.
What does it purport to be?
It's a aerial image taken from Google Earth of the defendant Daybell's property.
So, do you know who prepared that image?
I did.
Right. But you didn't take the picture
No.
because it's a satellite photo, correct?
Correct.
Have you been, I believe you testified you have been to Chad Daybell's residence.
Yes.
Have you walked around the grounds of Chad Daybell's residence?
Yes.
And have you been inside his home?
I have.
Are you familiar with the landmarks of that residence in the yard?
Yes, I am.
And are you familiar with the general layout of the yard and what's located in it?
That's correct.
And is this image an accurate representation of Chad Daybell's residence?
Yes.
Your Honor, for demonstrative purposes only, the state moves to admit Exhibit 10A.
Any objection?
Objection, one year remaining objection.
Right.
Officer, approximately how much property are we talking about?
I couldn't tell you the amount of property.
And the prosecuting attorney mentioned the yard. Now, I believe the yard usually means where there's grass. So you're familiar with what's on the grass, is that right?
I'm not sure I understand your question.
Well, and I'll represent to you that there's about 4.5 acres out there. Does that sound close to me?
Okay.
Okay. And I'll represent to you that there's an area that's known as the yard, that's a lawn area, that you would mow with a lawnmower. Are you following me?
Yes.
Your Honor, this is testimonial.
Judge, he says that he's familiar with the yard.
Well, I understand. I think we're going into cross-examination now, which will be permitted. The question is on an issue of foundation or other objection, whether or not the exhibit is admitted. So, Mr. Pryor, what would be the foundational objection?
He hasn't testified, Judge, that he's familiar with the pasture, 3.5, 4 acres of property that go beyond the yard.
All right, response, Mr. Wood?
I think the question is adequate.
All right, based on foundation and with the testimony of the witness about his knowledge of his property. Court will overrule the foundation objection, allow the exhibit 10A to be admitted, and you can delve into those issues by cross, Mr. Pryor.
Thank you. Thank you. Your Honor, I'll publish that shortly. Detective, so you testified that you executed a search warrant on June 9th, 2020.
Correct.
What time of the day did you arrive at Chad Daybell's residence?
Roughly 7 in the morning.
And was it only the Rexburg police or were there other agencies involved?
At that time, there was Fremont County and Rexburg City Police that went to his house at 7.
And did any other agencies help you that day on that search?
They did.
Who were they?
The FBI ERT team, which is the evidence recovery team, the Attorney General's office, Fremont County. I believe that's it.
Okay. And you testified you got there about 7 o'clock.
Yes.
When you first arrived, who was with
Mr.
you?
Wood, I do apologize. Could I have a quick sidebar with counsel? I'd like to discuss this exhibit.
Oh, we're live now, so I can't fast forward it. Meh. Yeah, Mickey, we're live. Yes, we are. They're on a quick sidebar. Mm. If you see a little red dot on the video, Mickey, that means it's live. I haven't watched it. I haven't watched. No, not yet. Not yet. Hmm. Well, I don't know where the red dot is on your phone, Mickey. Can somebody help her out? Because I'm looking for my laptop. Yeah, there you go. She says, oh, when I tapped the screen, it said live. Yeah. Let me bring people out of the lurk with the storm. Mm-hmm. Mm. Da, 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 da. You guys see Chad Daybell has got a laptop in front of him. What is he doing with a laptop? What is this Lemonhead doing with a laptop? Hmm. QB said Lauren will be here in a minute. She's not watching. Oh, there she is. She's got the laughy faces. Margaret says, The Lemon Life by Chad Daybell, Chapter 1, 12 Angry Lemons. He's writing a book. Right, Miss King of Anything? Yes, he's writing another bestseller. Mickey said he's probably Googling, who is Crime Cafe? Uh-huh. Oh. QB said she's probably flat asleep, and it was like you said her government name or government. The Storm. Who is Crime Cafe, and why do they keep referring to me as a lemon? Lauren said, I'll say nothing this time, QB. You know my thoughts. Hey, yay, yay. Hey, yay, 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 yay.
All right, Mr. Wood, apologies for the court's interruption, discussing that last exhibit. You can continue with your direct examination of the witness.
Your Honor, could I have the court reporter read back the last question I asked?
It's kind of a half question. When you first arrived, who was, the question before that was, and you testified you got there about 7 o'clock, answer yes.
That's right. Thank you. May I proceed?
Yes.
Detective, when you arrived around 7 o'clock, who was with you at that time?
There was myself, Lieutenant Ron Ball at the time, Detective Kai Kamani, and Detective Bruce Madigan, and also Detective Dave Stubbs.
All right. So can you go back through those individuals and say where they, who they were employed by real quick?
Lieutenant Ron Ball with Rexburg Police. Detective Stubbs is also with Rexburg Police. Detective Kai Kamani and Madigan are both Fremont County Sheriff's Office.
And just for clarity of the record, is Detective Ball still with the Rexburg Police?
No.
Okay, and what organization is he with now?
Madison County Sheriff's Office.
And Detective Kai Kamani, was he still with Fremont County?
No, he's also with the Madison County Sheriff's Office.
All right, that's just clarity, thank you. So when you got there, what did you do?
Initially, we knocked on the front door. We made contact with Mark Daybell, who's the defendant Daybell's son. He answered the door. He was eating a bowl of cereal. It was early in the morning. We informed Mark of why we were there and that we needed to speak with his dad. He stated his dad was still asleep, and we showed him a copy of the warrant, and he proceeded to let us in and show us where his father was.
And did you make contact with Mr. Daybell that morning?
We did. He showed us that he was sleeping in bedroom above a loft, above the garage. So we walked up the stairs, just a few of us. Detective Kakamani and Maddie stayed back. We informed Chad that we were there and needed to speak with him. He was still asleep. He asked if we could get some clothes on. We allowed him to do that and came downstairs.
And did you provide a copy of the warrant to Mr. Daybell?
We did.
And what happened next?
Mr. Daybell asked to speak with his attorney. We were standing in the kitchen area. He had a seat in the kitchen. And his attorney at the time was Mark Means. So we allowed him to speak with his attorney. At that time, Mr. Means wanted to speak with one of the investigators.
Chair, I'm going to object at this point.
That's fine, Your Honor. We'll stop that. Very well. After Mr. Daybell spoke with his attorney, what was the next step in your portion of the investigation?
I allowed Mr. Daybell to sit in the front room. He sat on his recliner closest to the door. His children sat on the couch in the same room. I gave Mr. Daybell a copy of the warrant, and he read through search warrant while sitting in his recliner. He asked if he needed to leave the residence while we conducted business. We informed Mr. Daybell he didn't need to leave the residence, but if he chose to stay, he would be accompanied by an officer just for safety purposes.
After you had that conversation, what did you do?
Mr. Daybell asked if he could make a phone call, and at that point he was allowed to go outside and make a phone call.
And where did you go?
I went outside with him.
And what did you do after that?
Mr. Daybell wanted to sit in the vehicle that was parked back in on the west side of the house. There's a west driveway. So I allowed him to sit inside the vehicle, windows rolled up, and make a phone call. I stood in the grass area close to the vehicle.
At this time, Your Honor, I'm going to ask to publish State's Exhibit 10A.
You may.
Detective, do you have that pointer?
Yes, I do.
Can you point out where the front door of Mr. Daybell's residence is? In that image, or where it would locate?
There's two doors. I don't know which one Mr. Daybell used as a front door. I can tell you there's a door right here and a door on the back side. So Mr. Daybell was roughly, that's not the vehicle he was in, but it's roughly parked in the same area. And I was standing here in the grassy area.
Earlier, there was some talk about the yard or the grassy area. Can you just outline for the jury where, I'm going to call it the grass area of the yard, is located on that image?
The grass area is right through here.
And is that a driveway behind the house as well?
Yes, there's a driveway here.
And to the just east of that, what is that? Is that grass as well?
There was grass here. There's a little shop area. There's a shed here. And then this is, I guess you would call it pasture area.
Did you observe any livestock there?
No.
Detective, you testified. If you can show again where Mr. Daybell was and where you were in relation to him when he went outside to make a phone call.
So Mr. Daybell was sitting in a vehicle fairly close to this location. He was sitting in the driver's seat. He was back in. I was standing here just observing Mr. Daybell make a phone call.
And did you observe his behavior while he was making that phone call?
I did.
What was the nature of the behavior? What was he doing?
Initially, he was just on the phone when I was watching him. But as the call progressed, he had the phone in his right hand and was intently looking over his right shoulder. And so I found it odd. I wanted to see what he was looking at. So I maneuvered myself to see what he was so intently looking at.
And when you did that, did you attempt to orient yourself so that you would be looking in the same direction you perceived him looking at?
That's correct.
What did you see when you did that?
So with the vehicle backed up here, he was looking over his right shoulder in this direction. I stood over here, kind of in front towards the roadway to see exactly what he was looking at. And when I looked that way, I saw this area, this pond area.
Now, let's look at that pond real quick. If you can just kind of run the pointer around it so the jury's sure where it is. Right here. And
There's a tree right here
thank you.
and then a pond.
And when, at the time, you noticed Mr. Daybell looking over there, was there any activity going on over there?
There was. So like I testified, we got there about 7 o'clock. When we made contact with Mr. Daybell and the scene was secure, we radioed for the other units that were staged about a mile and a half down the road that they can come start marking things off in the search warrant. So as time passed, Mr. Daybell was reading the warrant on his recliner. While he was doing that, there were ERT members and other officers that started marking off different sections in the backyard that we wanted to search.
Now, Detective, when, just for clarity of the record and for the jury, I believe you defined ERT earlier, but can you tell the jury again what ERT is?
Evidence recovery team
And who are they associated with?
with the FBI.
Now, Detective, were you the lead of this, executing the search warrant that day?
I wasn't in charge of the search warrant.
So, and if just for clarity again, what did you see when you looked in the direction you thought Mr. Daybell was looking at? Or I guess, what activity did you see?
There were some ERT members marking off a section under this tree right next to on the east side of the pond area. So right in this general location.
What did you do next in your part of the search that day?
I was tasked with going into the backyard and sifting through what we determined was a fire pit.
Can you show the jury on that map or on that picture where the fire pit is located? And you said,
I apologize, but for the record, would you have the witness please reference where that pointer just went somehow, so there's an oral representation?
yes, Detective, if you can point there again and describe what it is you're pointing at, where it is you're pointing.
The fire pit area, which there's like a little tree here. It's just to the north of the tree.
Yes,
Is that adequate, Your Honor?
it is.
So you said you went north of the fire pit. Exactly what did you do?
So a few of us were tasked with getting dirt and anything that was in the fire pit and putting it through a sifter. So that's originally what I was tasked to do by the team leader of the ERT team.
About approximately what time were you doing that?
I'd say roughly probably 9 of them that one.
Who was the team leader of the ERT team?
His name is Steve Daniels.
And how long did you sit in the fire pit?
I would say probably 35, 45 minutes.
And so when you sifted, what kind of tool did you use to do that?
It was a wooden sifter. We would scoop shovels full and put it in the sifter, and wooden handles. You would just shake back and forth. And any larger debris would stay on the top of the wire screen.
And did you find anything of interest while you were sifting through the fire pit area?
Not at that time, no.
Did you move to another area of the search?
I did.
When approximately did you do that?
You asked for a time,
Approximately, yes.
probably 10-ish maybe.
And why did you move?
There were ERT members and some other members of law enforcement that had marked off a place under this tree next to the pond. They had called and wanted some other people over there to help with that area, so I left the fire pit area and responded to this section right here next to the tree and concrete.
And what did you observe when you got over there?
I observed ERT marking off, they had already marked off probably a 6x6 section. The best way I can describe it is there was taller shrubs. In the middle of the 6x6 section, it looked like there was just a little bit of grass, probably the length of sod, and some dirt protruding through the grass, but there were no taller shrubs like on the outside of the section.
What happened next?
The ERT team began excavating that site. They removed a top layer of soil, took off the shrub and the top level of dirt.
And what did you see under that?
At that point, you could see what appeared to be 3 large white rocks. And as soon as they did that, we could start to smell the odor that, through my training experiences in decomposing body.
Let's talk about that. Have you, on other occasions through your work, smelled the decomposing body?
Unfortunately, yes, I have.
And is there a distinctive smell to you that you associate with that?
There is.
And it's your testimony that as that first layer of ground was lifted off, you began to smell that.
That's correct.
What did you observe next?
After they slowly and methodically dug around the white rocks, they were removed. ERT took pictures and measurements. They continued to dig down. Right below the layer of rocks were 2 pieces of thin wood paneling. Just right below the rocks.
Were you still able to smell that smell you had described?
Yes, as they dug down, it got stronger.
Were those boards removed?
They were.
What did you observe after that?
So after the boards were removed, you could see the discoloration of dirt. So you had dry dirt, and then underneath the boards was like a wet, moist type dirt. So it was pretty obvious there, the distinction between the soil.
Then what happened?
They continued to brush away the wet soil. And at that point, you could start to see a black round object start to protrude through the dirt.
And describe that object. About what size was it?
Initially, it just looked like a littler black round object. They dug down further carefully and it appeared to take shape of the crown of a human head.
What did you do after that, or what did you observe once that was uncovered?
So once the black round object was uncovered, at that point, the ERT team leader, Steve Daniels, got a small, sharp instrument and made a slit in the black plastic. He kind of opened that up just a little bit, not to damage or manipulate any of the evidence. But underneath the black plastic was another white layer of plastic. So he used that same instrument and got a slit down the white plastic and kind of opened it up. And at that point, it looked to be brown human hair.
After that was discovered, what happened next?
As soon as that was discovered, we received information on the radio that the defendant Daybell was leaving his daughter's residence, which was catty corner to his residence, at a high rate of speed. At that point, Mr. Daybell was pulled over and subsequently placed in custody.
Did you go back to the site where what appeared to be a human head was located?
I did. When I got back to what we ended up calling burial site, they continued to excavate around that black plastic. And after they excavated and took the dirt off the plastic, it revealed what appeared to be a small body wrapped in black plastic with duct tape around it.
Thank you. Your Honor, I know the time.
Yes.
This would be a good place to stop for the day.
All right, we are going to try to adhere to this court schedule, so it is 3:30. This time then, I am going to complete trial for the day. I've got one additional issue I'll take up outside the presence of the jurors. However, the jurors will be excused here momentarily. As you're leaving for the evening, then, ladies and gentlemen of the jury, as I will try to remember to tell you each and every day, or when we leave breaks, longer breaks, please do not discuss this case amongst yourselves or with anyone else. Please don't do anything to investigate this case. If you see any media coverage of the case, please try to avoid that so you can remain impartial. And with that in mind, that will conclude our first day of evidence. So we'll allow the jurors to be excused at this time.
All rise, please.
Thank you. Please be seated. Detective, if you want to go ahead and step down off the stand, we're going to just argue this motion. Council, this isn't necessarily a motion, it's just what I want to get on the record in terms of stipulated evidence the parties have agreed to. I'll note that back on February 27th, the court received a pleading stipulation on introduction of specific evidence. The list contains 74 separate items the parties have determined will be admitted at trial by stipulation. And let me just first begin there and inquire from the state, is this still an accurate representation of evidence that's going to be proffered and admitted by stipulation to your understanding?
To the state's understanding, it is, Your Honor.
Okay, and Mr. Pryor, you did review that before it was filed. You signed as well. Is it still your understanding that those listed items on the pleading are not going to be objected to if offered by the defense.
And by the state judge, that's correct, yes.
Very well. All right, so counsel, I am going to then indicate on the record that those particular items of evidence are to be admitted by stipulation. The one thing in keeping our record straight is that those are listed out in a 1 through 74 listing, but those do not correspond with the evidence markings in the case. In other words, those are not the exhibit numbers or letters that will be admitted in trial. So I'll keep the list running, but each one of those, of course, needs to be independently marked and admitted with independent trial stickers so the exhibits are kept straight in the record. And our clerk will assist with that as they come in, but I assume all of those are going to be pre-marked and admitted. And if you wish to reference them on the pleading throughout the trial, you can do that, but we need to make clear that all those exhibits are not. In other words, the pleading does not correspond to the actual exhibit numbers on the trial. Is that the state's understanding?
Yes, Your Honor. And maybe if I may ask for some clarification from the court.
Yes.
We do have in here, one of the stipulations covers essentially documents that are in relation. If we have a business record affidavit or a custodian of record affidavit, then we would stipulate that documents covered or the exhibits covered would be admitted. Does the court want us to introduce those business record affidavits or custodian of record affidavits as their own exhibit?
I'll let defense weigh in, but I think that makes the most sense to me. Separate affidavits should be admitted as separate exhibits, so those can be tracked down later if someone's referencing the record.
Judge, they're stipulated exhibits, so I'll let the prosecutor decide how they want to hit.
Okay.
Thank you, Your Honor, because I think at the end of the day, the affidavit itself is stipulated to, but really what matters is the content and documents covered by that affidavit or what's actually going to be admitted as evidence. So, but we have those if the court would like those admitted as well for the record.
Yeah, so they'd be separate. The affidavit itself, laying foundation for the other exhibits would be a separate exhibit.
And Judge,
Yes.
Judge, you will note that of my 54 exhibits that the state has agreed and stipulated to admit, the individual exhibits are the same numbers as the stipulation that we put on the record. So in other words, number one on the stipulated list makes mention of some phone cell information. The actual exhibit itself is the same number that I'm offering. It just happens to be the contents within that phone celebrate. So my numbers match up corresponding to the stipulation that the court has exactly. And I did that for ease of convenience for everyone, Judge.
Okay, and if they do match, we'll just reference that. If they don't, I guess the point is the stipulation itself is not any kind of controlling document as to what the exhibits actually will be marked as in the record. So we'll mark each one as it comes in on the record and make clear that this is simply a reference, basically. If they correspond, they do. If not, clarify that and it should be admitted in terms they're offered. Your evidence is introduced. So that will conclude then my concerns on stipulated evidence. Is there anything else we need to bring up this afternoon before we break for the day from the state?
No, Your Honor, thank you.
All right, anything further from the defense?
Judge, just briefly, the state and I will meet about that issue that we had at the sidebar, just the last one, to discuss the parameters.
Okay, I would suggest counsel will want to start with further testimony at 8:30. So if parties want to be available at 8 tomorrow morning, we can take up any matters outside the jury's presence before we get the jurors back in the court tomorrow morning. So that'll be our schedule for tomorrow. Okay, thanks everyone in attendance today for complying with the court's conduct order. You can be excused and we'll complete our day. Thank you. All rise, please. Folks, make sure you take all your things with you.
All right, you guys, that's it. So I am going to go and end the poll really quick. Kel, if you're still here, ma'am, and you want to chit chat, come on. Would love for you to come up and chit chat. And QB, Morgana, Steph, JB. What's JB doing today? You guys. We got 22 votes in the poll. Let's see. I'll give it a little bit before we close it, just in case anybody hasn't voted yet. See how clear that was? See how clear what was, QB? Oh, JB had live stuffs. Steph says you don't want me. Are you serious? Are you for real? I keep wanting to sing that song. Don't you want me? Don't you want me? The last video feed, it was just the judge and it was crystal clear, right? I know. See, that's why yeah. Come on down, the price is right. Come on. I want to hear your all's thoughts and opinions on the case, the trial so far. QB said Margaret was right. It's the setting. They just need to do the voice. Well, somebody email Judge Boyce and tell him that, Margaret, email the judge and say, yo, can you put it on the voice thing? Can you put it on the voice thing? That's what you need to do. I don't know. I feel like I saw a few people on Twitter that were saying the things about how the prosecution's opening statements were lackluster. Oh, we have a QB. We have a QB.
Hi.
Hi. What
Hey,
were your main
y'all.
takeaways for today?
I can't do 10 weeks of this.
I know, right?
I ain't even gonna lie to you. I'm like, can you just give me an update at the end of the day? Like, can you just, like, I mean, I know it's gonna get better. I'm not worried about, I mean, it's just the start. Like, we're actually starting to get into the good stuff, but, hey, Lauren. But, the audio and the video and it's a lot. And maybe why they
Actually,
only did audio for Lori.
it's the opposite of a lot. It's
It's not enough.
not
It's not
enough.
enough. So, but Margaret's right. They have different modes in Zoom, and if you do like a voice mode, whoever talks, they pop up on the screen.
Mm-hmm.
So, or you could have, I don't know, have one of those bailiffs that keeps running back and forth and taking exhibits instead of letting the lawyer approach. have one of them man it, and if they're doing stuff on the screen, just do a close up of the screen. I don't need to see everybody. I just want to see what's on the screen. I can't see what's on the screen.
Yeah, I know, it's very annoying. I wonder if they're gonna have, so tonight, Nate Eaton does,
Does he do a recap?
like a recap,
Yeah.
and I wanna see what he says about,
Probably big mad.
I wanna see what he said because, he's getting inundated with messages and texts saying, "It sucks in there." You know?
Hello.
What'd you say?
It's trying to connect to my headphones. There is some my phone is janked, y'all. It's bad. Uh who's probably big mad at the feed? Bob Motta is probably losing his ever loving mind right now.
Oh, probably.
I might have to go back and just check out, like, he and Jay were live streaming it. And I wonder if we should have a count, like how many times he goes. Do y'all think you could get a better feed on this? I can't hear nothing. I need a Snickers.
I thought that they were on vacation.
They were. I think they're back.
Oh.
I think they're back. Yeah, you saw all the goons come out when they were on vacation.
Mhm.
Start talking smack and stuff. He's like, I see y'all. Don't worry.
Mhm.
I see you. Just
Oh, we
putting
got a
on
kid. Whoa.
God bless America.
Hey, Kel.
Hi.
Coming in
How are
hot.
you?
The dog starts barking because she thinks I'm talking to someone that's here, but she can't see them.
Aw.
Anyway, I'm good. How are you guys?
Good.
Doing good.
That was like when I said hi to Jolie and she threw her fist at the thing because she couldn't see me.
Cute.
So, yeah, she wouldn't say
Yeah.
hi.
Well, for me today, it was like the flow was off. It was so not smooth. And I don't know if it's the attorneys or the questions that are being asked, but it just didn't seem to flow.
Well, I think they're letting this prosecutor get his feet wet. It seems like this is fairly new for him.
Yeah.
But, and I appreciate that, but I don't know if you want to let him cut his teeth on this.
Not on this.
Now, I will say there was a couple times that the defense attorney got some good objections in there. He's paying attention for sure.
Yeah.
And Chad's probably working. That's probably his paralegal because he ain't got nobody but him.
Yeah, kind of like Hannah Payne.
Yep. I wonder if they'll start matching like Hannah Payne and her attorney. They always came in wearing the same colors. Like they were doing that. That's all they've been talking about on the thug trial.
Mm-hmm.
Is that every day the whole team comes in and they're like all green and then they're all red and then they're all blue and it's like, what y'all doing?
I know.
Stop it.
They try to do the most.
The mostest.
The mostest. But I agree, Kel. Like Kel was saying, it just kind of felt like
It's
not
so
super.
lackluster. Like,
Yeah.
that's why I came in saying I don't know if I can do 10 weeks of this. Like, we may not have a problem when Karen Reed and Delphi and Suitcase Sarah and they're doing a thing on her Friday.
Doing a thing on who?
A pre-trial conference on
Oh,
Sarah.
on Sarah. Yeah, I heard that.
I'm sure it's going to get continued. There's no way that attorney is ready.
Mm.
But I mean, maybe, I don't know. Maybe they done. Maybe they're over her. They're like, nah, homie, we're going to court.
She needs to. She needs to just.
It needs to be done. Her biggest mistake was not saying that See, she was so busy trying to prove she ain't an alcoholic that she said she didn't pass out, but then she said she had all these beverages and they were like, "You didn't pass out?" And she was like, "Well, I went to sleep." See, I'd have been like, "No, I passed out like hard. Like it hit me and I was like, I'm gonna go to bed." And I forgot he was even in that suitcase.
Yeah.
Because she didn't put him in there. He got in there. I mean, she zipped him up, but he got in willingly. She didn't shove him in there. I'd have been like, we were playing a game and the booze hit me and I was like, "Good night, yo," and I went to bed and I woke up and was like, "Where my baby at? Where he at? Oh crap, is he still in a suitcase?" I'm
I
just
don't
saying.
know. I think she saw the prime opportunity.
Well, if she saw the prime opportunity, she messed it up. She messed it up big time. And she's
Mm,
videotaping herself. "Oh, well, that's how it feels when you choke me."
right, I know.
Ma'am, no, okay. If we have not learned anything in the crime cafe, okay, one, whether you're guilty or innocent, you always, always, always get an attorney.
Mhm.
Second of all, don't be filming yourself doing nefarious things.
Right.
Oh,
We got a kill back.
yeah, don't be videotaping.
Yeah. Oh. What? I muted you for a minute, Kel, because I don't know what that was. Can you hear me, QB?
I can hear you.
Okay, I don't know what that was. There you go.
Okay, yeah, because I couldn't hear, I just stopped hearing anything. I couldn't hear you guys talk, so I had to leave and come back.
Oh, okay. Okay. Yeah, I don't know. I don't know what it is. Spin said Kel's sound is real loud. I don't know what it is.
Oh, I'm real loud.
It's
Yeah.
like
I
it's
could
like
talk quieter.
No,
well,
it's
it's
not
not
your
you.
voice.
It's
It's
like
the background noise. Like, are you doing stuff in the background?
No, I'm just sitting here.
It, it sounds like you're walking through the house and watering the plants and feeding the dogs and
Wow. Maybe it's my earpods. I don't know. I have echo cancellation on and automatically adjust mic volume on. Is that better?
it's better now.
Okay. We'll see
But
if that.
now I'm not. Okay.
it
Kind of
always takes a
echoing.
while to figure things out.
Yeah, because I have to go into settings and change the mic from my phone mic to my earpods every time.
Yeah,
So,
that's annoying. I know. I fight with it all the time because I'm constantly switching from no headphones or no earpods to AirPods, and it's always I'm having to always mess around with it to try to get it fixed and figured out.
yeah.
So,
So,
I don't know. I think tomorrow is gonna be a really tough day. Because tomorrow they're gonna go the investigator is gonna be back, or the detective, I mean, he's gonna be back, and they're gonna be getting into uncovering the rest of JJ and then them
yeah, you could
finding
already hear him starting to get.
Yeah. It's definitely tough.
That's the thing. I don't know if I can tomorrow if the cameras haven't changed. No, I don't. I don't honestly know that they're going to change. They've been like this through every thing that they've done.
Yeah, like I said in chat, it might as well be just audio with these
Yeah,
cameras.
yeah.
So
I'm
I
not even
just
really, I'll be honest
listen.
with you, I'm not even looking at it.
Yeah, me either.
Every once in a while, if I can't quite figure out who's talking, I'll look up, but your noise canceling is not working.
Well, I just barely moved my diamond painting. I barely touched the plastic.
It's like
You have to go back and listen. It's insanity.
it's
Oh my
so like I
gosh.
knew exactly what you were doing. You poured drills, and then you moved the diamond painting with the plastic. You readjust it.
I didn't even pour drills.
Oh, it sounded like you poured drills.
Oh my gosh. Okay.
It's like magnifying it.
Why?
It is hilarious. It's like super ASMR, man.
Yeah.
What?
You have to go back and listen to it. It's like, look, Sherry's like, it was loud.
Oh my gosh, I'm so embarrassed.
Don't be embarrassed.
Embarrassed. Don't
I'm
be
glad
embarrassed.
I'm glad I didn't have the mic on when I was peeing then, because
Right? Or, you, whatever, pass a little gas or something. You'd be like, Kel, was that you? Ma'am.
Oh, Steph said it's like you're on a megaphone in an airplane. What?
okay, I'm gonna turn off my earbuds. Okay, this is
Okay.
ridiculous.
It literally sounded like it spins at an ASMR at a ranger.
Oh my gosh, what? Okay, this is just my phone mic. Is it fine?
That's better.
It's
Yeah.
better.
But
It
Well,
just
because
sounds
I
like
feel like you haven't started doing something yet. I feel like you're not doing anything. Like
I
you're
don't think I can.
You're
I'll
sitting
just have to sit
still.
here.
There's times, Cal, like I don't know what goes on, but they're like, I'll be over here with an e-file doing my nails and they can't hear me. And I'll pick up a regular file and they're like, oh, I see the cat filing its nails. And I'm like, y'all don't hear a whole e-file going off over here, but y'all can hear me just that little tiny file? I don't get it.
it's like StreamYard tries to like make audio things better for
They're
the
not helping.
user's experience, but then
It's not.
they like go way overboard and then they
it's
like
not.
try to
It's not.
write it and then they mess it all up again. It's you never know. You never know.
I will say this though, like I can like tell a difference from between here and when we talk on Discord
Oh yeah.
because y'all are like, are you washing dishes? Are you doing this? Are you doing that? I'm like, no. Maybe. But with StreamYard, I'll be running the water. I'm like, can y'all hear that? You're like, hear what? And I'm like, yay.
Wow. Okay.
So I don't know. It's a whole thing. It just was funny because I was like, she's definitely doing something back there. I don't know what she's doing. She's doing something.
I literally, like, when I came on, before it went all silent, I walked to the kitchen, I poured some iced tea,
Mm-hmm.
I set it down.
I heard
and,
I heard you pouring
all
the
that.
iced tea. Yeah.
and then it just went dark. Like it didn't go dark, but I just couldn't hear anything. I couldn't hear anyone.
Mm.
But anyway. Okay. I'm new here, by the way. Hi, I'm
Hi. You're fine. I jump in and out. Y'all, I am telling you what, I'm had enough with these nails. I'm done. I quit.
I need to go get mine done. I haven't had mine done in a
Over
long
here
time.
doing mine, and I am not doing a good job.
No, Steph, there was no ice.
No, I heard the pouring. I heard the walking. You've got hard shoes on.
No, I have socks on.
You were walking hard, ma'am.
Oh man, like a giant.
It sounded like. Oh, Spin says I can't quit. I quit, Spins. I have been messing with these same freaking nails. No, I quit. I quit forever.
Mm.
I got 2 now that are crooked. I cannot.
Oh, I hate that. That makes me so
I'm-
mad.
I am so, and I'm trying really hard. Like I have a barrier down so that I don't rip off my freaking nail. Sorry, my nail. And it's not helping when I have to keep taking the nail off. I'm done. I'm done with these. I don't think I like these are different tips than I usually use. I think they're not good. Oh, she said, ma'am. Ma'am. It's the same finger though. Maybe it's the finger. It could be the finger.
What do
Maybe
you
I
do
got
with
the
that
wrong side.
finger? Hmm.
It's not even a good finger. It's not a middle finger. It's not a pointer finger. It's just a ring finger. I don't use that for nothing. Maybe I got the wrong size. Maybe I got it sized wrong. Maybe that's it. Because it's the same finger on the same hand and it keeps popping.
Yeah,
Is
it could
it
be too
flat?
small.
Is that fingernail like flat compared to the others or
No, I've got,
curve?
well, see, that's the thing. I've got a barrier layer on there and they're all the same. But I always, come to think of it, I know this ain't the nail show. I always have an issue with this finger. Even when I file it, it never, like, it always seems thicker than the others. I don't know. It's just that finger. It's because it's the ring finger. I don't do nothing with that. Look.
That's if I'm going to mess it up, it's going to be this finger.
On both hands. Like, what is that? Can y'all hear me filing? I'm sure you can because I'm using that really light, really quiet hand file.
Nope.
Okay, good. Because I
Oh, I
use
hear it.
that e-file, which is, I mean, it ain't loud, but
Henny says the tip is too small if it does that.
that's what see, so I got, they're not, well, I think that finger is between a size. I think I need the bigger size and I need to file it down. So I used to hate saying or hearing ma'am. Then I met you, QB. Oh, I love you. I love you, Spins. Still didn't say something nice about yourself. I said 2 nice things about myself. Just saying.
Oh, Lauren's mom Henny's a nail tech.
Nice. I'm a nail tech wannabe. I'm a home DIYer that does my own because I have to hyper focus on something and I can't do crafts right now. So this is what I got.
Mm.
And this from a girl who normally has dirt under her fingernails and has them short. And so, but yeah, maybe, you know what? Oh, well, no, I filed it down. Okay, this ain't the nail show. I'm sorry. All right.
So let me ask you both. QB, you did not watch the Lori Vallow one, right?
No, I watched. You can't say the same thing I said, Spins. I watched the thing we watched the other day, the sentencing. No, what did we watch the other day?
Yeah,
Did we
it was
watch something with her the other day?
Yeah, it was the
Visine chick.
Yeah, but it was before that. We watched something with Daybell the other day, last week.
Yeah, we did like some of the different interviews and the audio.
Okay, yeah.
We did the audio of
the
her
audio.
opening
Yeah.
statements and stuff.
All right, cool. That's good. I'll take that, Spins. You are funny. So I watched that and then I did watch I watched that Lewis I don't think that's his name. That newscaster, he had Nate in there, and I guess he really followed the case. This guy, I swear it's Lewis. I could be wrong. And it was like a comparison thing, or not a comparison. It was like a montage, like an 1.5 hours of all the things Lori Daybell.
Oh, okay.
and I had sent it to you, and then I put it in. I think I put it in. I'm trying to be better instead of just sending it to you, putting it in. Let's see if I put it in here. I put the timeline in here. East Idaho News, I think, is the guy, but I can't remember his name. And if I click on it, it's going to take me out of here. Anyways, I've watched some of that. So no, I have not watched the trial. I remember seeing her come into court one day, and she like skipped into court. She looked like a cheerleader.
Mm-hmm.
And I was like, you awful happy for somebody that, I mean, let's talk about the poll. Did you?
Oh, I haven't closed it yet. But Kel,
Okay.
are you familiar, or were you already familiar with Lori Vallow and Chad?
Yeah.
Okay.
Yeah. Overall, yeah. Mm-hmm.
Okay. I didn't know if you were or not. And because some people like know it, and then other people not so much. So
I mean, I'm probably in the middle somewhere. I don't know everything, but I'd like to think that I know the majority of it.
okay, good. Good. So how did you two vote in the poll?
I voted that they 100% believed it.
Yeah.
I did not vote that.
So you think it's a lie that
I do.
they think that that's a lie?
Mm-hmm.
Yeah.
If that's true, how would you explain them not having a plan to get out of all the suspicion and the missing kids? Because that was going to happen eventually.
I mean, other people don't have a plan.
True.
I mean,
You
I
think?
don't know. I'm just not buying that I don't know. I mean, I heard her. I vacillated between the two. I'm not gonna lie. And I just felt like it was like this way of getting what she wanted, getting people out of her way. I mean, okay, Tammy's in the way. Okay, now Tammy's a demon. The kids are in the way. Now the kids are demons. Charles is in the way. Now he, tried to attack her.
I mean, I don't dispute that it's very convenient, but I believe that her belief system, her faith, was a means to an end. Yeah, I do believe, deep down that she did have ulterior motives, but a lot of people do really shitty things and claim it's for religious reasons.
Absolutely, and that's what I'm saying though, is that I'm not saying that they weren't Mormon and that they didn't have faith, but I'm saying as far as this stuff went, as far as they took it, no, I think it was a means to an end.
Okay.
That's just my I mean,
Yeah.
we'll
Yeah.
do the QB, disclaimer. I felt, and I will say that I'm like you, Kel, I'm somewhere in the middle. I kind of know a little bit about both of them. I don't know a lot.
Where'd she go? Oh, hold on.
Of all that is holy.
You bounced.
Of course I did. I will say when I heard the conversation between her and the friend that she said that JJ was with, Melanie,
Yeah.
and she was talking about, I know my kids are fine. I know they're good. I know they're where they're supposed to. I mean, when she was talking about that, she was very convincing. I mean, and that's the only thing that gave me pause was that conversation. Because she was she was convincing.
And she would need to be in order even for herself to believe that she did the right thing in killing her kids.
Right.
Like,
Mhm.
how else could you live after doing that if you didn't think it was the right thing to do?
Yeah,
But then,
I mean,
it goes to mental illness. I have a hard time. I believe people can be evil and do intentionally evil things. And then on the another side, I believe that some people are mentally ill and act accordingly. So it's a fine line. And then on the flip side, like, some people can't believe that anybody in their right mind can do something, so they have to be mentally ill, even
Mhm.
though they could be sane and just made a decision to benefit themselves.
yeah, yeah. Well, I think they're all of the above. And then there's those that try to use it, and say, and I don't think, I mean, if you kill someone because you're mentally unstable, that can be the reason why you killed them, but I still don't think that it excludes you from being
Punish.
held responsible.
Right.
Now, that
Mhm.
may mean just like, okay, case in point, Gypsy Rose, the boyfriend. Okay.
Yep.
I think they did him wrong. I think he
Mhm.
is mentally unstable. I think he's also got some other issues um, that have gone unaddressed, and they got him straight up in prison just doing time. I don't think that's okay. Now, do
Mhm.
I think he needs to be punished? I do. Do I think he needs to be in a facility that can help him? I also do. I don't think he should be out free. I mean, you're mentally unstable and you killed somebody. So, yeah, that's not a thing.
Right.
Do you
But
feel he could be rehabilitated, or, helped with meds or therapy,
I
or?
don't know because I don't know entirely what his issues are.
Mhm.
I do think personally, I could be wrong. Personally, I feel like he's on the spectrum, and I think it went
He is.
unaddressed.
That's already diagnosed.
Well, but it hasn't been addressed. I didn't know it had been. Is that Jolie? Hi.
Yeah.
I didn't know it had been diagnosed. But really, both of them really didn't have any kind of stable home life. I don't think. Um, but so I don't know what the mental issues are. I think he definitely has some. I also think wasn't he tested? Wasn't he IQ tested?
Yeah, he was.
So
There
help.
was
So
something like that. And I think also, like Steph had just mentioned, the dissociative identity disorder.
yes.
Yeah, he had that, was diagnosed with that as well. So, I don't believe that he needs to be in a uh,
Sorry, I got a phone call.
whatever. I mean, I guess if you want to call it like a maximum security prison, I think he should be
Oh
in
yeah,
a medical type of facility for criminals.
absolutely. And I mean, you could have him in a a maximum, a maximum security prison with a mental ward. I hate to call it that because that ain't what it is, but you understand what I'm talking about.
Right.
And because I don't know, Kel, I don't know. I mean, if it's dissociative, okay, and autism, if he got medication, okay, and counseling and address the autism, could he be rehabilitated? Maybe. I don't know.
I don't know.
I can't say either way, really, because again, that's one of those things that I don't, in that realm, I don't know enough about. I know Gypsy Rose needs to get some help.
Literally.
Um, and I'm not being mean. I mean, she literally was gaslighted her whole entire life and abused and held hostage and all the other things you want to talk about. Do I think it makes it okay that they killed her mom? I don't, but
Yeah, I think that's just another one of those whole, like, it's not a black and white. There's a whole lot of
yeah.
gray. in the
I
middle.
feel like you can. I feel like you can feel like someone is guilty and also have empathy.
Oh yeah, yeah, yeah.
Yeah.
You know, I
And that's
mean,
how I am with Gypsy Rose. I
yeah, I
mean,
mean,
'cause
you can feel like,
you hear people say all the time, "Oh, well, I don't blame her for doing what she did because she felt like it was her only way out." And and then people argue about that, about, "Oh, well, I mean, she could have just walked away. She could have done this. She could have done that." And yeah, you're right. She could have, but you don't know. I
put
think she had
nobody in there
tried.
with her.
She had
Not,
tried to get away before, and things kept
we're
happening.
talking about years and years of mental abuse.
Like
And
Right.
from a very small child.
yeah, when people say, "Oh, you could just leave," yeah, maybe you could physically leave, but the fear that has been, you know, incorporated into your everyday life,
And
it's
mentally,
not possible.
she was homeschooled and then they just like dropped it.
Mhm.
So, and I think she's highly intelligent. I don't know the book smarts part of it because that wasn't something that she was given.
Right.
And she was totally dependent on her mother. Her mother drugged her for years.
I think she did get her GED in
I think in prison, I think she
in
finally
prison, I
did.
think she
But I'm
did.
saying we're talking about when she was in the house before the mom was killed, and people are saying, well, you should have just got out. When you turned 18, you should have just got out. Well, first of all, she didn't even know how old she really was until later
Mhm.
because she lied on the birth certificate. I think it was maybe 5 years difference or something.
Well, it was different. She changed it once, and then when she got closer to 18, she backed it off again
Yeah.
by a couple of years.
Yeah. So I
Um,
know that was messed up. So I mean, yeah, she got her GED. I'm not saying any of that. I'm saying, but when she was in the home and mom controlled everything, I think she stopped doing homeschooling at like third or fourth grade.
mhm.
And then mom had complete control of everything. She drugged her. I'm sure she had her believing she couldn't do it without her. I mean, that would be fitting. Um, so anyways, I don't know how we got on that.
Wasn't there a movie on one of the
Yeah.
platforms based upon her story?
Yeah, there's a couple. One of them, they say it's not based on her, but it's pretty daggone spot on. And then there is one, and then there's a newer one, like Confessions from Jail with Gypsy Rose or something like that. And
Yeah,
it's
that
not,
that popped out. That was like
it's,
there was 2 or 3 series of that one that was,
yeah,
popped out whenever her release started
yeah,
being talked about again.
yeah.
Oh,
And so, but, I feel like the boyfriend got a bad shake.
Yeah. Well, I know that he was trying to go up for, file an appeal or something. I don't know whatever came of that or whatever, so no clue. I don't know. How did we get on the subject of Gypsy Rose?
Uh, it was my fault. I don't remember what I did, but I scrolled out. Um,
I'm like, how did we get there?
well, we were
As
talking
far as
about something, and then I was like, "Oh, it's like this," and I was like, "Well, look at the boyfriend." And then, yeah, it was my fault. I totally scrolled out.
as far as the whether the Lori and where did Kel go again? Kel gone again. Um,
It's always
and now QB's gone. Lord have mercy.
Lord.
Oh, now they're both back.
oh my gosh.
Hi.
Hi.
I'm telling you, QB's internet is
It's not.
contagious.
Listen.
Mm-hmm.
I just stopped being able to hear everything again. I don't know what's going on.
What does Margaret keep saying? It's retrograde. It's
Mm-hmm.
Steph's cat. Mercury.
Yeah. Oh well. But what I was saying about Lori and Chad, for me personally, I go back and forth between the two. Yeah, they're done for the day, Sherry. We're just chit chatting before we call it a day. They'll be back at 8:30
Yeah,
Mountain Time,
10:30.
10:30 Eastern. So as far as Chad and Lori go, Mickey and I have talked about this before, and I'm like, I feel like that Chad and Lori feed off each other. Um, and I feel like they have the whole like gasoline and
Flame.
yeah, like water and gas, or however that, what is that phrase? They're like,
Fire and gasoline.
okay, that's how they are. And it just does not, they don't, it's not a good look. It's not a good look.
My thing is everybody keeps going, well, there's no, and I okay, I'm playing devil's clavicle here. Y'all just don't come at me. All right. But what I do know is that during Lori Daybell's trial, the prosecutor made it all about that she was the mastermind. She was in control. She ran everything. She, so I'm still wondering, how are they going to get to the death penalty with him? Because they can't come in now and say, well, she was following Chad. Well, you just said, sir, over here that she was the mastermind. You can't even legally do that. So it'll be interesting. I'm waiting to see what they have, because, or how they've come at it, because unless they can prove that he started it, he did it all, he made it happen, I don't know how they get to the death penalty.
Well, the jury instructions indicated that they are not supposed to worry about the penalty and whether or not they find him guilty or not.
Right. Well, and they shouldn't. But
So I could, some people would need to know that it had to be by his hand in order to, for him to go to death row. And, is that up to the jury or is it up to the judge in this state?
in this state, I have to look. Where are they? Idaho?
Oh, are you
Idaho.
asking if the jury or the judge is the one that calls the death penalty?
Yes.
It's the jury.
That's
Okay.
what I thought. I thought it was the jury.
Yeah, because
so
it was part of their questionnaire. But
yeah. I don't know how they
so they
get to
can
that.
find him guilty, but decide not to go with the death penalty.
Yeah. It's just such a big deal because the death penalty wasn't on the table for her.
Well, that wasn't because she shouldn't have gotten it.
Oh no, not at all. If it was going to be on for anybody, it should have been her. If they were going to go down the road that they went down, which was, it was all her. I think the prosecutor made a mistake going hard like that. I don't think she thought about what she was going to have to do when it came to Chad. Because they went so hard that she was the mastermind, they left themselves without anything.
It doesn't really matter though, because this jury is only supposed to consider the evidence that's presented before them.
I know,
so it doesn't matter what happened in the other trial.
It does though, Kel, because the prosecutor can't come at Chad and say he was the mastermind and he did everything. It's not allowed by law. He can't spin one story to one jury and spin the same story on another person to another jury. He cannot do that. And so they won't hear, oh, Chad was the mastermind. Oh, he, orchestrated this whole thing. He, blah, they can't use that. because they
But
used that on Lori.
I get it. It's not really a requirement necessarily either.
No, but I mean, if you want to sentence somebody to death or find them for first degree, I mean, you got to pretty much prove that they premeditated, thought about it, made it happen, all the things, and they can't do that. They might be able to, but it's going to be I think they have an uphill battle because of how they presented Lori.
But the interesting thing is because there's the conspiracy charge, they're almost proving their case by proving conspiracy. Because if two or more people are conspiring, to commit a crime, they're equally culpable
They
of the
are.
result.
You are correct. But if they can't, if they, again, and I'm playing devil's clavicle
Yeah.
here. But again, if you say what they said in Lori's, which was basically she was evil incarnate and she got, she held the puppet strings for Alex and for, everybody, and she had everybody doing her bidding, then how do you then come here and say Chad was a willing participant? If she orchestrated everything, if she was manipulating everybody, if she was, using sex and drugs, and not sex and drugs, but you know what I'm saying? If she was using all those things to get what she wanted, then how can you say that he conspired with her, that he was a willing participant?
He doesn't have to be the ringleader to be a participant.
No, but he has to be a willing participant. He has to have an agreement. It doesn't have to be
willing.
written.
He was willing.
He was willing to get, yeah.
He got what he wanted out of it too. It wasn't just one-sided.
And I'll tell you, I don't honestly believe, I mean, nobody wants to spend life in prison, okay? But I don't honestly believe that I mean, I hope they do what they did like in the Visine thing, that they can't profit from this.
Yeah. Because he's going to be a writing fool in jail.
Oh yeah, absolutely.
He probably
absolutely.
already is.
And they'll be notorious, which I think is one of the things they wanted, personally.
Mm-hmm. Sex and Kool-Aid, says Margaret.
Sex and Kool-Aid, yeah, for sure. Yeah, Mickey Jo, I mean, I'm not discounting any of that. I'm just saying I feel like the prosecution painted themselves in a corner by going, because they didn't have to go that hard for her. Or either one of them. I mean, if they would have come at them equally and they were willing participants together and they planned this whole thing and they schemed this whole thing, and I mean,
well, I know they had that whole conversation about it in the last hearing that they had, about how the judge was like, yeah, you can't, come at this jury, the prosecution, and say, oh, Lori was the ringleader, and then go into this trial and the prosecutor say, oh, Chad was the ringleader, that Lori was just the second, so I think
all
they're
I'm saying
smart
is I'm
enough.
interested to see what they come up with.
Yeah. I think that I have no doubt that they're going to be able to figure out. They're going to be able to come
he's
up
got
with
me doubting
whatever.
so far.
I mean, I don't even think that they need to come at him that hard, because there's evidence that they did conspire. They did talk about this. There were plans.
Right.
So I think that's enough for me. I wouldn't need to know who made up the rules. Just like look at Gypsy Rose's dude who's still in jail versus her ass is out.
Okay, then how come Chad couldn't be like Gypsy? And they give him manslaughter, or they get him on the insurance fraud. I'm just, like I said, I'm just playing devil's clavicle.
This is
because
healthy. This is healthy banter.
It could be. I mean, because it could happen. I mean, look at Casey. I mean, we keep saying it, but look at Casey Anthony.
But
I think they went at her. I think they went at Casey Anthony because they thought they had it signed, sealed, and delivered, and all they had was circumstantial, and that jury couldn't get to it
because there was too much speculation about what actually happened. Unlike Gypsy Rose, it was clear whose role was what and who who actually who her mom died at his hands, right?
Right.
So, but with Chad and Lori, we don't really know. So
No, it's probably
I
Alex.
think you don't need to know that. I think if you do know that, then it's easier to let Gypsy Rose out
Right.
versus,
But
but because
okay.
we don't know, then to me, they deserve the same or, and
But
I
if
don't,
okay, Alex is dead. Alex can't speak.
right,
Okay.
right.
And they've already said, okay, the defense has already said Alex would do her bidding. And it's been shown. I mean, she would blink and he would say, okay, what do you need done? And so, and I don't know, there was some kind of freaky relationship between them. I haven't figured it out yet, but she had a hold on him. And so if, let's just say,
So they
hypothetically,
blame it on him.
well, they could say again, she's the mastermind. Okay. She had Alex doing the bidding. Alex, let's just say that she says that Alex put those kids in his yard just in case she needed an insurance policy. I mean, do you really think that they planned all this out and then Chad went out there and dug a shallow grave when he was a grave digger?
Not by him, no, not by
No.
himself.
I don't think he buried them.
But he knew where they were because he ran just at the right
Oh
time.
yeah,
And they were right at
he knew they were there at that, maybe after the fact. I'm just Devicle's clavicle. They could say, yes, he knew where they were, but after the fact.
No, I don't believe that
What
because he sent that message to Tammy saying, "Oh, by the way, I just shot a big, massive
Yeah,
raccoon and
Right.
buried it out here in the backyard."
that's what
And
I was
here's
about to
another
say.
thing. Here's
Did we
another
find a
thing.
raccoon?
They didn't look for a raccoon. That was his way of saying if somebody heard a gunshot during the daytime while you were gone and the neighbor comes and says, "Whoa, I heard a gunshot over here," or "I saw somebody digging in your backyard," then he's
Yeah.
got an alibi for why somebody heard a gunshot. And he said it only took one shot for that raccoon.
And he even started that thread with guess what? Guess what? I shot a big raccoon or whatever the heck animal it was.
Yeah.
And
Yep.
he
Mhm.
was so excited. And she said, good job.
Mhm.
No, and I
Um
agree, Mickey Joy.
also
You have the
also
principal theory.
also you have Lori, who's mad because whenever they find out that um that either Brandon or Tammy won, I can't remember if it was Brandon or I think it was Tammy. Whenever Tammy thought she was getting shot by somebody with a paintball gun, and she's like, "Oh my god, blah blah blah." The next thing you know, Tammy sends a message to somebody, or somebody overhears Lori on the phone saying, "Oh my god, he always messes everything. He never can get anything right." Saying that she was talking about Alex because he missed.
Right.
Yep. The first attempt.
Okay. All I'm saying is, I'm not saying I believe any of it. I'm not saying I believe any of it. I'm just saying that the defense could spin it in a way, and the prosecution opened the door for that.
Right.
You're
I
right.
think.
Juries are weird sometimes. They do some crazy stuff. So
I
who
mean,
knows?
who would have thought when we first all okay, and I know some of y'all have watched it, some of you haven't. We're not going to talk about it because Steph will come at me. But the apple dumpling trial, when we first saw that, right? Okay, Apple River
Yeah.
stabbing.
Mhm.
We were all like, that man sliced and diced them children.
Yeah.
What was wrong with him? But then you start watching it and you're like, wait a minute. And then the defense attorney gets in there. And I don't know, I haven't gotten to his testimony yet.
I
I
watched.
don't know what he said on that stand, but I know that there were people that were gobsmacked and were like,
I want to hear your opinion after you watch his testimony because I watched it.
like people are like, there's no way that it was not self-defense
I don't
after
know.
he tested.
After his testimony, I don't know. Watch it. Because he doesn't
Okay,
remember a lot of what happened,
right.
even hours and hours and hours after the fact. And I
Yeah.
understand being in a fight or flight mode or in shock,
Shock.
even.
Yeah.
But we're talking 4 hours after the event, and he's talking to police. He can't remember the lies that he told. He can't remember saying it. He was still in shock. I have questions. So I have thoughts that I've already put in my phone for when the time comes that we discuss it.
I want to see it. Yeah, I'm on like I was in the rabbit hole last night. So I'm on, I think, day 5. And I'm fast tracking kind of through it because there's certain stuff where they're kind of, revisiting stuff that I've already kind of seen, even though it's just a different person. Um, and so, but that defense attorney, he ain't no joke. He, I mean,
Mhm.
he even got the guy that the detective was, I don't remember if it was the detective or I don't know, one of the guys, that was on the stand with the state, which all but said he murdered that kid, and he gets him up there, and he's like, well, he was kind of in a trance, and then the defense attorney gets up there, he goes like, somebody that would be in shock, and the detective was like, well, yeah, but, and he's like, I mean, you've seen people that are in shock, right? Are they trance like? And he's like, well, yeah. You know, their defense attorney's good. But there's a serious, it's kind of like with Richard Allen. There's a serious divide on this case.
Mm-hmm.
People, there ain't no middle ground on this. People are either like he did it or he didn't.
My
But
my main issue with this one is self-preservation, right? So take it, he's saying he felt like he was being attacked by a group of kids. Now, when he finally walked off and saw a police officer for the first time, if your life was just in danger, through self-preservation, wouldn't you say, I need help, police? I need help. I would be frantic. I would say, I need help. Those people just attacked me. I would probably just be like vomiting at the mouth. But he just said, oh, I heard you're looking for someone.
right, and he matches my description.
Right. And
But
it's
if
like,
you
if
were
you just felt threatened, if your life was just in danger, wouldn't you want help? Just, I don't care if you're in shock. You would, self-preservation, you would ask for help.
well, I have dealt with a lot of people with shock, and I have seen people not do that. The other thing that I'll bring up is that he's also not from the United States. And I think that factors into it. They don't trust law enforcement. They don't trust law enforcement like other people do.
But he was
And I know he's been here a long time. I know
just
he's been
deceptive from the jump, like he had something to hide.
right. Well, I mean, I can see it. I can see it both ways. I can see it both ways. I can see it from a shock perspective. I can see it from not being originally from here perspective. I can see it from he was trying to cover it up because he just sliced and diced 4 people. And maybe it wasn't on purpose, but does it matter?
Right.
I mean, they were just hollering at him that he was a pedophile. Can I say that? I guess I should have asked that before I said that.
Yeah.
That that he was looking for, small children, that he was so in that situation and in that trauma, would you not think maybe I just need to get out of Dodge?
Wait until you hear what he says on the stand about what his level of anger was, what his level of fear
Oh my,
was.
yeah. Sorry. I dropped out. I'm
Because
not yelling at you.
he talks about his, on a scale, what was your level of fear? What was your level of anger? So yeah, I'm sure we'll get in deeper to this at some other point, but I don't know what would be fair because like so many, it's just tragic, the whole
It's
thing.
absolutely, and I've said that from jump. I don't think anybody deserved to be stabbed, killed, any of those things. And it's sad because either one of them, and I include those children, okay? Here's my problem with people saying children, okay? If you gonna play like an adult, then you don't get to claim I'm a child.
Right.
You're out there drinking alcohol like you an adult. Guess what? You don't get to say, well, but we were looking for the adults to come help us. No, homie, you were acting like an adult. You were out there smoking and drinking and doing all the things like adults do. You can't have it both ways.
Yeah.
I don't feel like you can. And does that mean that I don't think that their mind, that they don't have the, I'm not saying their minds, but that they don't have the experience and, you know, the life experience that they need to handle those situations? No, they don't. But if you're going to go out there and play like an adult, then you need to expect that you're going to be handled like an adult.
Yeah. Like when I was young, I put myself in really dangerous situations, and bad things really could have happened to me. And I'm grateful they didn't. But being in a dangerous situation and recognizing it is key. And it seemed like no one knew the intensity until it was all too late.
Yeah. And see, what Mickey Jor is saying is that after that open heart surgery, it changed her brother-in-law.
Mm-hmm.
It changed him. Even his wife said that.
Mm-hmm.
That wife's testimony broke me. You know what really got me? What really got me like angry with the prosecution is that they put that child that died, that Isaac that died, put his mama on the stand, and it had no evidentiary value at
Yeah.
all. And they broke her. She was broken. I mean, she's already broken, but they made it worse. And they put her up there for nothing else than a show.
Yep.
And I have a problem with that.
Yeah.
There was no need for that.
I
There
mean,
was
but
no need for that.
if she felt like that's what she had to do to get her son justice, then
Sh
maybe it
That's
was,
fine, but she didn't act like she wanted to be up there.
yeah.
And I agree with you. If that's what she needed, then great, go up there. But she didn't act like she wanted to be up there.
Yeah.
I'll be right back, ladies. I gotta go wee wee.
Go wee wee. Just turn the, I don't know, Gail. The other problem, yeah, the lawyer, now I haven't watched that one yet because I haven't watched his testimony, but I've seen some comments on the videos, the other videos, and people are like, they are going hard. I mean, they're either guilty or not guilty. There's no gray area.
Yeah.
There's
The majority of comments I saw were all saying self-defense, but
Yeah,
that
but
was
there are those hardcore guilty.
before
M-
his testimony. So,
my issue, another issue that I have is, and I've said this in the past, is that I can't get to first degree intentional.
right.
And I feel like the prosecutor thought they had it in the bag and they overcharged it.
Yeah.
And I can't get, no matter what story you spin, no matter what scenario you believe, I cannot get to first degree intentional. And I don't know how they get a whole jury to that.
No, I don't think they're going to be able
No,
to.
I don't think so either. And like Gail said, they'll either be hung or they'll find him not guilty.
Right.
Because you can't, and that's the problem that I have, and I've said this in the past, is that prosecutors get so egotistical about how good they think their case is that they overcharge, and people who need to be punished walk free.
Now, I've seen times where like they may be charged with first degree and then second degree and then manslaughter, and then the jury can pick. But why don't they do that more often then? Why do they just go for first? Can you hear me? Ay, ay, ay. Can you hear me now? Hello? Oh, QB dropped. Oh no, I don't want to be in charge. No, 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 no. I thought my mic went out again. Okay. Hi guys. I have a joke. How does a lady control her liquor? How does a lady control her liquor? She grabs him by the ears.
I leave for 2 minutes. QB drops and Kel's up here
Telling dirty jokes.
telling dirty jokes. Lord, Lord, Lord.
Spin said, hold him by the ears. I'm back.
That's the answer. You got it.
Spins. Spins.
Ay, ay,
Wow.
My bad. Don't leave me
So,
in charge. Don't do it.
I was cracking up. Kel, I was cracking up. I was like, now you know how it feels, because they do that to me all the time. They leave me in charge, Kel, and I drop out. Excuse
Yeah.
me.
But you're so good at it, QB. You're just a natural.
I am not. I don't know. Anyways, so you were talking about the lesser included. So they'll do like first degree and second is a lesser included. Okay.
Yeah.
And so the jury has a choice. But when now I can't remember. I'll have to look into it. I can't remember if that's like an after the fact thing that they can do. But the defense would have to agree to it, and in this instance, I don't think they would. But when the prosecution thinks that they have their case in the bag, they're like, no, I mean, we're just going to go for we're going to go first degree intentional, and we're going bigger, we're going home, and they don't give a lesser included.
Yeah.
And I think that's a mistake. I
Yeah.
always think it's a mistake. I mean, okay, if you give me a choice of you can have, that was a bad analogy.
Unless there's a confession. If there's a confession, a taped confession, I get it.
Even then, though, you could argue it away. But I mean,
Yeah.
like, okay, that kid that killed his girlfriend, that was guilty. He had a confession. He pled guilty, but they wanted first degree, and he was trying to get second degree or something like that. In that instance, yeah, I mean, let's go for first degree, and let's go for, let's give it all we got. We have a confession.
Yeah.
And so that's fine. But I think the biggest mistake they made was going first degree intentional and nothing else.
I agree.
Now, I thought, didn't they say, are you all still talking about the apple
dumpling gang? Yeah.
So I thought they said that there would be lesser includeds.
I haven't seen or heard what the lesser included are thus far. It has been solely first degree intentional. There was first degree intentional, and then there was like there's other charges, but they're not and ors. They're ands. It's like
I thought it was I thought that I read somewhere or saw somewhere about the second degree and involuntary manslaughter or something.
Bye, Spins.
Bye,
Bye,
Spin.
Spin. Spin said
Thank-
I'm so good at these jokes.
Look what
Bye,
Margaret
friend that's
said.
not here.
Look what who said?
Margaret.
Oh, seriously. This is going to be a paid channel. Y'all keep it up like this.
Right? Okay, so blah blah blah, yada yada yada.
Yeah, we might as well wait for Burger.
Yeah. Okay, so he's charged with first-degree intentional homicide for Isaac and 4 counts of attempted first-degree intentional homicide on the others.
Wow.
Told you.
I want to try something out real quick. So we had 24 votes. I'm going to end this poll. The question was, dun, 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 where did it go? The question was, see, my computer is being so slow. It's not wanting to show up for me now. Are you guys seeing the poll?
Yard.
It'll show up any second on my YouTube thing. It just takes it.
It's there.
Yeah, see, I'm not seeing it yet. Hold on. Hold on. Oh, Margaret says, oh, here it is. I just now got it.
54, 25, 20.
Yeah, 54% said yes, they 100% believed in it. 25% said not sure, and 20% think that no, they were lying to family and friends.
I'm in the 20.
Pretty split.
Mm-hmm.
I'm in the 20. I'm not convinced. And I will say I vacillated between the two. Cause, but like Kel said, they have to be convincing. If it's a farce, they have to be convincing.
Right.
So, but that brother had a very unhealthy, I don't know if it went both ways, if it was just him, whatever, but yeah.
I mean, she knew how to manipulate everyone.
Everyone, yeah. Absolutely.
So she found out what made them tick, what mattered to them most, and then just played on it.
And where she got had was that Melanie chick who doubled down and was like, no.
Does anybody know how this Q&A thing works in the because like where the poll thing is, I can also start a Q&A, but it says where I type something in, it just says say something. What do I say? Like, are you guys supposed to ask questions or do I ask questions?
You ask a question.
You ask a question. I don't know. I just followed Kel on that one. I have no idea.
I'm pretty sure you ask a question and
well, here though it says start a Q&A and then it says answer viewer questions live.
Oh, then we get to ask you stuff. Woohoo!
Ask us. I don't know. Let's try this out.
It won't shut everything down like I tried to do the other night. You know what's funny, Kel, is she'll leave me in charge, but she always leaves herself up because then if I fall out, it won't end the whole stream. Because if she leaves me by myself and I drop out, the whole thing goes down. She tried to do that to me the other day. Oh, Kel is gone.
Kel's gone.
Lord.
She's back. Okay. Do you guys see anything in the chat? It says,
ask us anything. Let's try this out.
Okay.
Lord. That means they can type anything in the chat and we need to answer it. I don't know how I feel about all that.
Oh, Margaret said she asked something.
Where? Oh.
I don't.
Okay, she hit ask something. Wait a minute.
Okay. Oh, okay, I see. Steph says, then it says ask something and we click it and ask, but it goes privately to me. Yeah, that's how it's working.
Okay,
Oh,
yeah, I can't see it.
yeah,
Okay,
me
what happens if I click on it? If I click on it, hold on, I've got
Will it
this
show up on
live
the screen?
action thing. Select question.
Oh, I'd like to know if I can take a poll. Absolutely not, ma'am. Come back next year.
That's cool. I like
That is
that.
cool.
No poll for you. Come back
No
1
poll for
year.
you. Come back 1 year.
I'm gonna have to go on my computer to see it.
It's coming up on my
Okay.
phone.
So
If I
then I
go
Wait.
over
can.
to YouTube, not on StreamYard.
But won't it cut me off if I close out my web?
Okay, so you don't close it. You go over to YouTube, you open it and hit pause really quick.
I'm not doing that.
I'm just
I'll
saying
go
that's
on
how
the
I have to
computer.
do it because,
Okay.
well, I have to do it that way, Kel, because my StreamYard is fighting with my YouTube. They're not talking right now. And so I can't do comments. So I have to go to YouTube for my comments.
That's okay.
It's very annoying.
I'll just go here.
And now I have, okay, so Steph and oh, wait a minute. Who would win a fight, QB or the Squirrels? Oh, that's a hard one because I'll let y'all answer it. I guess I can't answer it.
Yeah, Steph asks who would win in a fight, QB or the Squirrels?
My money's always on QB.
Well, some days the Squirrels win.
Facts.
I think it depends on if you've had your Ovaltine for the day.
Mm.
This is pretty cool though. This is pretty cool.
Steph said, dang, I hoped it was anonymous.
It's not. Look, Lauren said QB. See, this is why Lauren and I are going to be friends forever.
All right,
for the
so
win.
here we go. Here's another one. Let's select this question. It's from Henny, and she says, how are you girls doing? So, Kel, how are you doing today?
I don't like this question.
Next.
I keep getting yelled at for my answer, and I don't like it.
I'll tell you how I'm doing today. I'm doing good because I'm here with y'all. We're waiting on a co-burger.
I'll go with you on that. I can't say because I always go, I'm good or I'm okay, and then like later on, it's like my arm hurts or whatever, and then the doctor's like, if you're okay, why are you here? That's what the ortho said. She goes, how you doing? I go, I'm okay. She goes, then why are you here? I was like,
that's rude.
But true. She ain't wrong. But I told her, I'm like, I'm tired of complaining. Like, I'm so tired of complaining. And she's like, here is where you complain. This is where we fix things. Okay, fair. Then the PT got me yesterday. So I don't know. I mean, my attitude is good. My body thinks it's 90. I don't know.
I hate that. The days when you wake up, when your body really feels like it's like 90.
Every day. And you got to understand, I've been going through this a long time because I got autoimmune and all the other things. And so Em and I actually compare medications. Like, it's ridiculous. She's 84. She's like, oh, I take that. I'm like, ma'am, you are not helping me right now.
Oh, yay. You guys are asking more questions. Okay, hold on.
Uh-oh, I
Gail
fell out.
has
Oh, no, Kel fell out.
Uh-oh, hold on. I'll go get her. I'll go grab her.
Go get her.
Gail's question is, what do y'all really think happened to Alex?
Okay, wait,
let me
before
start.
y'all
Let me go
answer.
first. Let me go first. Let me go
Wait,
first.
I have a question. I have another question on top of the question because I don't know. How did he die?
They said natural causes.
What kind of natural causes?
I think it was heart or something.
Okay, because I need to know because in my mind, I think she killed him. I think she done did it.
So I feel like they said he was foaming at the mouth in the bathroom.
Was he? You know what that's indicative of?
Poison.
Poison.
Right.
Thank you, ma'am. She came in hot. She said poison. Now you can foam
Poison.
at the mouth when you die. It can happen. It can happen when you low oxygen and heart attacks and all that stuff. But most of the time, it's indicative of poison.
Well, they did an autopsy and they did say that they found nothing in his system.
Did they check for Visine?
I
Right.
know.
Did they check for prick marks between his toes?
I'm
Just
sure they
saying.
did. They look at that kind of stuff
No,
now.
they don't. Not all the time.
They look at the toes. They look between the toes. They look for weird things.
Do you know how many cases have gone unresolved and the only reason why they ended up finding them is because they still had them on ice? They don't look. They don't look. These little small towns, even the big towns. Anyway, sorry.
Yeah, Zulema was definitely a follower of Chad's. Yeah, that's how her and Alex got together. Was Chad and Lori introduced them to her. And when you think about it, someone, I can't remember who it was in here in the chat the other day, had brought this up, and they said, I can't remember who it was. Somebody had said that they thought that he may have killed himself because he finally got to the point of like, okay, I've done all this and stuff, you know?
Or
Here's the
alternatively,
thing.
she convinced him that he needed to.
I think he knew that it was coming. I really feel like he knew it was coming because was it you, Steph? Because remember they had that whole they did that what was it that Chad did that he prayed like some kind of a prayer. It was a blessing, some kind of a blessing over him, over Alex. And it literally sounded like something you would pray when you're getting ready to know you're getting ready to die. Do you remember that, Kel?
Not really.
Let me go see if I can find it.
I'm just saying.
Let me go see if I can find it. Oh, it was creepy. Hold on.
I ain't buying it. Everybody else in her way or that could tie her to anything or that could keep her from getting what she wanted died. And then the brother dies and he's young and he just happened to die from natural causes. Nah. They thought Tammy died from natural causes too. They dug her
Here
back
it is.
up.
Here it is. Here it is. The patriarchal blessing Chad Daybell gave Alex Cox 2 weeks before he died.
That could have been a dose of something.
Okay. Now, here, listen to this, okay? I'm going to play it. I'm going to share this. We're going to listen to this, you guys.
Like Steph said, they were casting him.
No, it wasn't a casting. It
No,
was
but he got the evil and they had to take him out. That would be what their excuse is. She's supposed to go. I thought I heard something. She was supposed to go on trial for him, or is it for Tammy? No, she already did Tammy. I thought it was, or for Charlie. It's Charlie. Never mind.
Yeah, it's for Charles and Brandon.
I got it. Brandon didn't die though, right?
No, but they've got attempted
Yeah.
murder
Because
charges.
because Alex shot out of the back of her daughter's car. I mean, derp.
Right. So these patriarchal right or blessing was 2 weeks, they said.
Zulema.
Nah, she had Zulema do it or he did it himself. Definitely not an accident either way.
Mm-mm.
Well, and they said that he had went to Mexico, like, because he was sick and he went to Mexico to get some kind of medicine. Yeah, I don't know. I don't know about all that, but let's listen to this. This is creepy. You can hear Alex crying and
I bet he is. He knows.
oh, it's creepy. All right. So here this says 2 weeks before Alex Cox died, Chad Daybell cried as he gave Cox a 15-minute patriarchal blessing promising that he was elect and a warrior for God. A patriarchal blessing is given to members of the Church of Jesus Christ of Latter-day Saints by someone who has been asked to be a patriarch by church leaders. The patriarch gives promise, counsel, and lifelong guidance intended solely for the recipient. Daybell was giving the blessing to Cox on his own accord, as it was not his calling within the church. Daybell laid his hands on Cox's head and gave him the blessing on November 24th, 2019. Cox's sister, Lori Vallow Daybell, was in the room for the blessing and can be heard saying amen at the end. Cox died on December 12th, 2019. An audio recording and written transcript of the blessing were admitted into evidence during Lori Daybell's murder trial Thursday. You can listen to the recording in the player above. All right.
Jenny.
Yeah.
They're live.
Oh, shoot. Dang, dang, dang. Can
Here,
somebody
I got the
see?
link. It's in, I'll drop it in, here, I dropped it in YouTube because that's the fastest way for you to get it.
Okay. I can't open that. Can you
Oh,
send
you
it in the
can't?
private chat?
Yeah. Headed there.
Yeah.
I didn't know you couldn't get it there. I thought that was the fastest way. There you go.
Well, it would be, but I can't open it. The
Oh,
links are
okay.
not like hyperlinked in
And I can't put it in the back.
it won't let you put it in the back chat?
It cuts it off. No, I did it in Discord. I mean the back chat of StreamYard. It's in Discord.
Oh, let me run over there and grab it. Thank you, ma'am. Thank
You're
you, ma'am.
I'll be interested to see what he says. I got 2 nails on, y'all. Then I'm done. I'm not doing any more. I quit.
Okay, hold on, let me mute it. Let me scroll it back to the beginning.
I don't know what not the girlfriend just made, but that smells good. I'm gonna need. Dang it. See, I get to playing with y'all, and then I don't eat dinner.
Okay, so now we have this up. Okay. All right. Okay. Let me hit play on this. You got too many tabs up. Hold on. Here we go.
Thank you. We are now on record. This is State versus Brian Koberger, case number CR 29222805. Mr. Koberger is here in the courtroom, represented by Ms. Taylor and Ms. Natheth. We've got Mr. Thompson, Ms. Jennings representing the state.
Did he just say Liz Taylor?
Yes.
Ma'am, I could have swore that's what he said. He said Ms. Taylor, but I thought the same thing.
We have Mr. Nye and Ms. Beatty on Zoom. Anybody else on Zoom? Ms. Taylor?
No, Mr. Logston is not going to be on Zoom today. He had the other hearing.
Ms. Beatty made it apparently. So, and I have, also, you have Mr. Edelman, Dr. Edelman here today.
I do, Your Honor.
Okay. Great. So I think what we're doing today is just a continuation about the questions, particularly on the surveys and where we go from here. You did drop off a sealed exhibit, right? Anything to say about this, or just?
Yes, Your Honor. That sealed exhibit goes with one of our discovery requests, that the exhibit that outlines what we're requesting has to be under seal. And so I had to hand deliver that to the court. A copy was hand delivered to the state. It is not up for discussion today.
Okay, great. Thank you. One other thing to just tie up is the order unsealing the state's motion for order prohibiting contact with prospective jurors. There was a discussion between both of you about redacting a particular sentence, maybe last time, and so that we were going to take care of that.
I didn't, Ms. Taylor indicated that there was a sentence she thought we might want to consider redacting. I haven't heard back on that, and I know that she's been busy on other things since the 6th.
We want to just talk to each other for a second.
I understand the microphones in the courtroom are very sensitive. Perhaps we should do this after court today and go ahead and do the testimony of Dr. Edelman first. And I'd be happy to talk to the state afterwards.
Right. All right, so is that where we're starting now?
Yes, Your Honor.
Actually, Judge, I think we need to discuss some preliminary matters first.
Okay, go ahead.
As Your Honor indicated just a moment ago, this is a continuation of where we were on the 6th. And the issues on the 6th and the issues that we have here today is first, whether there was violation of the non-dissemination order. And if so, where do we go forward from that point? And I think it was clear from our discussions on the 6th that the fact-specific questions did violate the order. I realize that the defense would like to proceed with those questions. That's perhaps an issue for today. But I just wanted to define what we're looking at today, because about 10:45 this morning, we got what was up on the screen there, a PowerPoint that apparently Mr. Edelman prepared. And as I understand, I don't think Ms. Taylor got it until sometime this morning herself. That's the information that I was given. And we have concerns because a large part of this PowerPoint deals with the issue of a change of venue itself, which is we are not prepared to address. It is not before the court at this time. It is premature. And I don't think that it should be part of this record as we proceed forward today. And so the state took a copy of preparing a printout of the PowerPoint. It doesn't take long to look through it. Perhaps the court might want to take a look at that before we proceed, at least with eliciting things from the PowerPoint. And I realize it's last minute, but the last time that we presented something to the court in advance, Ms. Taylor complained profusely. And I realized it was only 10:45 when we got this today. And so we just figured we would raise it with you now.
Okay, thank you, Mr. Thompson. Ms. Taylor?
Your Honor, I would disagree with counsel that the court made a determination that we violated the non-dissemination order. In my mind, that issue is very right for the court today, as is where do we go from here with the survey? Dr. Edelman has made himself available in court to explain the survey, the process of the survey, why it works, how long it's been used, how widely it's used, and what it doesn't do, and what it does do to present the court with some options to make a decision where we go from here. Whether the court decides we violated the non-dissemination order or not is up for discussion, and we're prepared to further argue that, but we think you need to hear the testimony first. As far as this PowerPoint, I had access to Dr. Edelman yesterday afternoon and we worked on it late. I didn't have a final copy to give to the state until this morning. So they have it. We are not arguing venue now. We're talking about survey and how that relates to our change of venue motion. We know we're arguing the venue change later, but we have work that we still need to do. And that's where we are today, and would ask to present our PowerPoint and present our testimony with Dr. Edelman as we've prepared to do.
Okay. Yeah, so
Actually, our Ms. Taylor still has a copy of the PowerPoint that made available to the court.
okay, so seems like this happens to me in this case that there's an argument about whether I should go ahead on something or provide some information that I don't see yet. So I feel like sometimes I'm making decisions that I'm in the blind here. So I'm gonna look this over. Any problem with that, Ms. Taylor?
Well, Judge, give me just 1 second. Your Honor, the purpose of the PowerPoint is to inform the court about the questions in the survey and the purpose of them. I can tell the court that showing up every time we want to have a hearing and have to fight to have the actual hearing is something I haven't experienced before either. There is nothing in that PowerPoint that the court can't hear today when making the decision about where do we go from here and did I violate the non-dissemination order. There's just nothing wrong with the process that we're doing here, and you're continually being asked to say there's something wrong with what we're doing. We're 10 after 4. I have a witness who's traveled here today and we're ready to go.
All right, Your Honor, just to clarify, as we made clear the last time we report, we are not saying Ms. Taylor herself violated the non-dissemination order. We're saying that the people who prepared the survey and disseminated the survey and called citizens of Latah County with those fact-specific loaded questions violated the non-dissemination order, and they are agents of the defense. So I don't want this to become personal between Ms. Taylor and myself. We are not alleging Ms. Taylor has done anything wrong. We are dealing with reality that this survey was conducted on, as we understand it, 400, I'll say, innocent citizens of Latah County who were force-fed information that they may or may not have had about this case before they were called by the survey takers. And they are loaded questions. Some of the questions are factually wrong. They simply aren't true. That's what we're here about.
And that's what we're prepared to address, Your Honor. That's why we have a witness here. And if there's violation of the non-dissemination order, it's me. I'm the one that's bound by it. And the court just needs to hear about this process instead of hearing the conclusion that the state wants the court to reach.
Number one, I'm past that. I'm not going to violate you. I mean, this was a communication problem with Dr. Edelman not getting the order. One of the things I think that maybe you need to clear up, not for counsel, but maybe the public, is that one of the terms in that, and this is in the ethics, right, is what is the public record? Public record is not traditional media. It's not social media. It's not what anyone might say in public. Okay, that's the problem that we're kind of balancing here, because the public record is case that is available to the public in this case. I mean, I think we can all agree with that. No?
No.
You think the public record is whatever the media pumps out?
Your Honor, I think it's what's in the public, and what's in the public is derived from the affidavit that supported probable cause to arrest Brian Kohberger. That's the first document that the court finds in the whole cases of interest on Idaho State Supreme Court's website. That document has a ton of information in it that relate to the questions in the survey for the case-specific questions. So that document became public record, and that was spread far and wide all over the place and reported and interpreted repeatedly. That's the public record. That's where the questions came from. There's no violation of the non-dissemination order if that's what we're going to talk about today, but I think the court should hear from our witness and understand a little bit more about this survey process.
I'm very interested in that. I told you last time that I'm interested in what he has to say about this, but so you're saying that the public record though comes out of the case, right? That's public.
I'm saying in this case, that's exactly what happened, Judge. I don't want to argue the finer points of what's in the media, but I'm saying in this case, that's exactly what happened. That affidavit's there, and this court knows we have a ton of things that are filed under seal and more things that are not filed under seal. But that affidavit that began this case has been shared far and wide, and media stories have generated. When you understand how Dr. Edelman does his work to determine if a survey even needs to happen, you'll know where the information came from.
Okay, so I'm understanding, okay, the initial probable cause affidavit is part of the public record. And you're saying, well, that got spread, okay, by the media, as you would expect. And that's something that could be concerned. So what I think maybe, I don't know, what Mr. Thompson is talking about though is information or questions that were not in the public record. And so what I'm nervous about this is I don't want to continue to spread things out that shouldn't be spread. And so I don't know what's in the slides, but if there's information in the slides that are not in the public record, that really have not been disseminated generally, then I mean, I don't really want to spread it. None of us want to spread it more than necessary.
Well, last week in court, that was right inside the courtroom. That all became part of the public record. The 9 questions were stated repeatedly in different formats by Mr. Thompson. That's part of the public record. We've been accused of violating the non-dissemination order. Dr. Edelman's reputation has been impugned by what was stated about him repeatedly. Those questions are fair game. But having this hearing and allowing our expert to talk about this process, that's not the problem. The problem with the media happened a long time ago, and it started with the sharing of the affidavit far and wide.
I understand that. I'm pulled in 2 different directions right now because I'm trying to protect your client at the same time. So if we keep talking about this, what is not true. Okay, I mean, I guess we can just say, well, it's not true on some of these questions. Maybe that helps to reduce bias. But if we don't make that clear, then it could increase bias. I think. I don't know, tell me, maybe
Well,
I'll hear this from the expert.
I'm going to say it like this. Mr. Kohlberger's my client, and his rights are of the utmost importance to me. Him being treated fair, his presumption of innocence, him having an impartial jury, those are important things to me, as is his right to counsel. I am not standing up here saying, let me tell you about this survey. Let me finish this survey to hurt him. I'm saying there is pervasive media coverage in this case. It's prejudicial media coverage. We've conducted a survey in Latah County. That survey is going to show bias and that you shouldn't have a trial in this county. What I'm trying to do is say, do you want me to give you information about another place where maybe the bias isn't so great, where maybe Mr. Kohlberger can have a fair trial? I'm his advocate. I want to help him. I believe in his innocence. I'm not going to stand in this courtroom and do anything wrong to him at all. I need you to hear the information so you can make a decision, to have the surveys, to have the information when we come back here for change of venue and make a decision on all of the information. Right now, if we come in and do our change of venue, we're going to say you can't have this jury in Latah County, but I can't tell you a better place that will protect him better. And that's what I want to do.
Any response, Mr. Thompson?
We aren't here to argue about venue today. We aren't here to argue about what this particular survey with the loaded questions, fact-loaded questions, may have produced in Latah County residents. As we mentioned last week, the structure of those questions assumes that every person that is called has heard all of the media in this case. And we know that that just simply isn't true. So for those citizens in this county who have not heard all of the rumors, who have not been following the media, who haven't inspected the court record, who are essentially ignorant of facts in this case, well, that's just been jaundiced by the questions that were asked. They have now been force-fed facts, some of which are not true, some of which would not be offered in court, and in fact, probably wouldn't legally be admissible in court, to somebody who may never have heard them before. That's the state's concern about the way this thing is put together. And the arguments from the defense seem to be completely ignoring that point. That there are people out here who don't know all the things that they were being asked, and by asking the fact-specific questions, we were inoculating them with information that they didn't have before about this case that could affect their ability to sit as jurors. It's just simply irresponsible. It doesn't make sense.
Listen, this is one of the things that I was thinking about, is maybe we can inoculate by saying you can't rely on any of this information. It's not established by evidence. It's not been provided in court. But to just send a message out to be clear that these questions have nothing to do with guilt or innocence or even truth.
But that's not what was done, Judge.
I know. We have to fix this in some way.
Yes, sir.
That's what you said last time. And so I just want to help the public understand that this is not the trial.
Your Honor,
Yes.
at this rate, we may never get to trial. We know this isn't the trial. We brought Dr. Edelman to talk about the process, which will answer the state's concerns about this process. He hasn't even had a chance to tell you how this is constructed. He's the one that's the doctor of this kind of work. He's the one that's the professional. He's the one that knows how to do this. He's the one that spent his career understanding surveys and how to construct these. You need to hear from him. Going back and forth between what Bill thinks and what I think doesn't matter. What matters is you hearing from the expert to make a decision. He's here, he's ready to testify. We're 20 minutes into this hearing and he hasn't been allowed to take the stand yet. He came to inform the court about this process.
Well, there's no question I'm going to let him testify. I just wondered about what's in this. I haven't looked at this, but it's you're comfortable having this come out into the public?
Yes. After last week's hearing, absolutely.
Okay, and you looked at it, Mr. Thompson?
You have concerns,
Is
Judge.
it alarming?
Well, part of what's in there is a part of the survey study being published now, if this comes to the public, without any comparison to anything else. And it's the product of these loaded questions. It takes us back to the fundamental issue of how this survey was conducted and the assumption that the people who were being called already knew all this stuff. And so it didn't hurt to specifically ask them, have you heard about such, the specific item? Well, if they hadn't heard about it before, they sure as heck have heard about it now. That's the core concern that led us to this in the first place. We don't dispute the defense doing a survey. I said that last week. Please do a survey, but don't go around screwing with the knowledge that prospective jurors have or may not have. That's our concern. And Your Honor, when we parted ways last week, the court said, Ms. Taylor, talk with Mr. Edelman and see what the options are. Well, my understanding from the email I received day before yesterday is the survey cannot be changed. That was from Ms. Taylor reporting what Dr. Edelman said. I interpret that as they don't want to change it. Anything can be done, but that's where we're left. I would have been happy to engage in discussion with defense about maybe some middle ground, but the line has been drawn black and white. I am concerned about the specific things that relate to venue, partial survey results that are in this PowerPoint. I believe it is premature for them to come out now. The rest of it is fine. Let's bring it out so that you have whatever information you want. You can give it the weight that you decide. I just didn't want to let this willy-nilly come into the public record in a half-baked fashion.
I have lots of concerns. We're not left with this because I have to make a decision about several things.
Yes, sir.
And so in order for me to have the most informed decision, I need the information. So they're just going to go ahead. All right.
Thank you.
And you can show your slides, and if something is concerning, we can talk about it along with it. All right. So, are you ready to call your witness? I think you are.
I am. I'm ready to call Dr. Brian Edelman.
Okay, Dr. Edelman, if you could please come forward, face the clerk, raise your right hand. There you go.
You solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
All right, thank you, sir. If you could please take your seat there. And then once you're comfortable, please state your name and spell your last.
It's Brian Edelman, BRYAN EDELMAN.
Thank you. Ms.
Thank you.
Taylor.
Good afternoon, Dr. Edelman.
Good afternoon.
What do you do for a living?
I work as a trial consultant, and also I do quite a bit of work as an expert witness in the field of pretrial publicity and change events.
Are those two separate roles?
Yes, they are.
What do you do when you're a trial consultant?
So as a trial consultant, you're an advocate for your client. You do mock trials, focus groups, to really try to develop a trial strategy, a trial story for your side, and cultivate that for the audience, the jury. We also do jury selection. I assist with writing voir dire questions, juror questionnaires, help ferret out bias during voir dire, recommend cause challenges and how we use peremptories, do post-trial interviews. I do jury-related research, present my findings at conferences, bar associations, law firms, and so on.
When you work as an expert in the field of change of venue, does that differ from your work as a trial consultant?
Absolutely.
How so?
Well, as I mentioned, as a trial consultant, you're retained to be an advocate. As an expert, you are retained to be an objective expert, which means I'm not advocating for either side. I do not advocate for the defense. I do not advocate for the prosecution. My role is to collect information using standard methods that have been widely accepted in the field, and then present the findings to the court so they can make a well-informed decision on whether or not any remedial measures are necessary. So there are times where my findings support what remedial measures, like a change of venue, and there are times they don't. And when they don't, I recommend against a change of venue, whatever the data supports where I go.
I want to understand a little bit about your educational background that allows you to do that work.
Okay.
How were you educated?
I'm sorry?
How were you educated? What degree?
Starting in grammar school.
We can skip to college.
Yeah. So I have a bachelor's degree in psychology from Florida State University. From there, I attended the University of Nevada in Reno, where I studied social psychology. my particular interest was in the application of social psychology in the field of the legal arena. So I was really interested in juror decision-making, jury decision-making, group dynamics, how people process information and evidence, the impact on pretrial publicity, pre-existing attitudes, and that sort of thing. The school I went to really focused on that area. That's where the National Judicial College is, the Grant Sawyer Center for Justice Studies, and several professors in that field. So I conducted research at the Grant Sawyer Center for Justice Studies. I helped run a program through the Department of State that brought in judges and attorneys to the United States, where they would travel around the country to meet with people in their field. So I work with the National Judicial College in that regard as well. And then from there, when I finished my PhD, I got a Rotary Scholarship to study in the United Kingdom, where I got an LLM in International Humanitarian Law, which I do not use.
During the course of your career, have you been published?
I have. I've been published in the area of survey methodology. My research was on the death penalty, so I have a book published on the death penalty. I am the co-editor in California. There's something called the CEB, the Continuing Education of the Bar, and there's a criminal procedure book that comes out every year. It's kind of like the Bible for criminal procedure, and I'm a co-editor on the chapter on change of venue. I was also on the committee for the American Society of Trial Consultants that publishes professional guidelines for writing change of venue surveys. So on that. And I've also done research on, one of the questions is always, well, why can't we just pick a jury in a high profile case? So I've done research on the use of the set aside question. So if people have been inundated with a lot of prejudicial media coverage, how do they respond to that set aside question? Do we see, for example, if somebody's been exposed to a lot of prejudicial coverage, you'd expect them to say, I cannot be fair and impartial, I know too much. And so we were looking at research on that as well. And then last thing I promise is, I've also done research on what's called minimization language. So when you ask people an open-ended question on a juror questionnaire or in voir dire in a high-profile case, this is the only standard question, what have you read, seen, or heard about this case? That's the open-ended question. And people minimize what they know. That's something Dr. Ed Bronson came up with because he had noticed it. And that's like using language such as, I only recall what was in the paper, or I just followed it. I just remember it was on the news. And they don't really elicit a lot of information. It's minimized knowledge. So did research on that too.
That's been part of your research?
Yes.
When you work as an expert, if you're hired as an expert to work on a change of view issue, and I think you told us how your work is different than when you're a trial consultant. Can you tell me how you start in that role as an expert for change of venue?
Yeah. So first of all, I've been doing this for about 15 years, I'd say, as an expert witness on this area.
On change of venue
on change of venue.
Okay. And to do with surveys, just to be clear?
Yes. From some of its surveys, other times it's post-conviction, and once again, I've done federal cases, state cases, multiple states, including Idaho. But the way I learned was from Dr. Ed Bronson, who was kind of the pioneer in the field. He worked on cases like the Oklahoma City bombing case and a host of other prominent ones, the Boston Marathon, a bunch of them. So he was kind of my mentor in this area. And there's a 3-stage process. So the first phase is collecting the media coverage. Because really the question is initially, is there extensive coverage and is there prejudicial coverage? So I collect the coverage and assess the nature of that coverage. Does it include inflammatory language? Does it include inadmissible or misinformation? Now, just because it's not true does not mean people don't see it, and it does not mean that they don't develop opinions based on that information. So it's very important. In fact, some of that stuff is the most prejudicial stuff that there can possibly be. For example, if there is a prior conviction and then the conviction's thrown out, well, that's pretty prejudicial for the new trial. Not admissible, but very prejudicial. So I'm looking for information like that. I'm looking for references to prior records. Maybe there are victim impact statements where victims' families may be suggesting what the outcome should be. That could be prejudicial. How did the community respond? Are there candlelight vigils? Are there, GoFundMe efforts going on? The status of the victim, is it focusing on that? So there's a gambit of things that we look at. Sometimes there's political elements that are important in high profile cases because it might be that a politician's involved. So it just depends on the case. So the first thing is assessing the nature of the publicity. Now, if there's not a lot of extensive pretrial publicity and it's not prejudicial, it stops there. And that's happened where there's coverage, but it's very superficial. It's very neutral. There's not a lot of detail. There's nothing particularly impactful. Maybe it's focused primarily on just the victim or something like that. However, there are other cases where there is extensive pretrial publicity, and then I would recommend phase 2, which is a community attitude survey. Because just because there's prejudicial coverage does not mean it had an impact on the jury pool. And that is the question that matters most. What impact has the prejudicial media coverage had on the jury pool? I don't really care if it's correct information, it came from social media, it came from the news. It had an impact on the jury pool. That's what matters, because they develop opinions and attitudes. And it doesn't make a difference if that fact is true or false. They still develop an opinion and an attitude about the defendant, about the evidence and perceptions of guilt. All of that is what I'm looking at. So I want to see if the media coverage has had an impact. And that's why we do a community attitude survey. And then depending on the results of the survey, there's not enough evidence there to suggest that anything is required. It could be remedial measures such as individual sequestered voir dire. Maybe that's appropriate in some cases, all the way to the extreme case where it might be a change of venue.
I want to understand a little bit about the source of media you review to do your work. Can you tell me what you take a look at?
I always take a conservative.
Your Honor, I'm sorry, I need to object. This PowerPoint is being played for everybody with no foundation. It's not an exhibit. I think that's improper. I mean, I'm trying to listen to Dr. Edelman's testimony, and I keep seeing slides changing in front of me over here, and I don't think that's appropriate.
Well, you've seen the slides.
I have.
You looked
But
at it.
everybody else here hasn't.
What I'm seeing here, though, is just an explanation of how he goes about in surveys.
Understand that. That's what his testimony is. But we're getting this visual aid that there's no foundation for, Judge.
Well,
It just seems
I'm hold on. I'm viewing him as an expert. Okay?
Yes, sir.
He's explaining what he does. So I'm going to.
No problem with that. The PowerPoint's a problem. I don't have any problem with his testimony.
All right.
I'm sorry. Frankly, I've never seen something like this occur.
That objection. I mean, this is not necessarily factual. It's just an example of how he got to where he got.
That's his testimony, but the PowerPoint is different, Judge. I don't know why we're seeing the PowerPoint when we have his testimony.
You want to respond to that?
I do, Judge. This is a courtroom demonstrative aid that helps to track the testimony of Dr. Edelman. I can hand him my computer and let him advance the screens if that makes a big difference in it. This just helps explain his testimony.
Judge, we don't have a jury here. Let's just proceed.
Okay. Thank you. Proceed. Go ahead.
Dr. Edelman, we were talking about where you get your information.
We were talking about the what?
Where you get your information. What media do you look at? I think that's where it was.
Yes. So I take a conservative approach to how I do it. I look at newspapers in the local coverage right now. So I'm interested in papers that have primary circulation in the venue. Case like this has been reported in many other newspapers, but I wouldn't, for example, look at a newspaper published in Dallas because I don't know if somebody in Latah County would be looking at a paper in Dallas. So I look at the local coverage. I try to look at like local television coverage to see what the community is likely exposed to.
While we're here, I want to ask you some questions about the non-dissemination order.
Okay.
That's been a hot topic, and you've heard some of it again today. Are you aware that there's a non-dissemination order in this case?
Yes.
How did you become aware of it?
Well, the first time I became aware of it was when I was reading the newspaper coverage, because that was one of the topics of media coverage, was discussing the non-dissemination order and media's efforts to have it changed. So I was able to read it and follow it in that media coverage. So that's the first time I saw it.
And in January, did you receive an email from my office with the non-dissemination order?
I believe I did.
And you looked at a hard copy again recently?
Yes.
All right. Does that non-dissemination order change how you did your work?
I'm sorry, can you even though
Does the existence of the non-dissemination order change how you did your work?
No, it did not.
Have you worked in cases where there's a non-dissemination order at other times?
Many times.
Was the sole source of the information that you use contained in the media?
Was it came from the media? Sorry. Yes. Everything I use was widely disseminated through the media. Widely disseminated.
Did you find out where the media got the information?
Yes.
Good afternoon, folks. My name is Bill Thompson. I'm the Latah County prosecutor. And it's sad to be here, but happy to be here at the same time.
You turn it up. I can't hear.
Kohlberger.
Well, I'm gonna do my best to turn this up.
Yeah, you get a fancy.
Oh my God. This is hilarious. It's like, can you show me where you found it? Yeah. Here's a video of the dude sitting at the table next door. I can't. This is like a circus show right now. Oh my God. Okay. Let's go back.
If I put the microphone up, is that better?
So, yeah, but Christie, you don't have to type out things that are recorded here.
I'm waiting on him now to say, right, Kel, definitely scripted. I'm waiting on him to say, objection. I object to me.
This is what I'm saying though. Look, he knows he put out the information. He put out the information. And look, I'm not saying Kohlberger is guilty or innocent or anything. I'm not saying anything, but dude put out this information. He put it out into the public. Okay. It was in the affidavit. It was all public record. All right. And he did that on purpose to bias people against Brian Kohlberger. And now that she's calling him on that, you can hate her. That's fine. But she's doing her job.
Right.
And you know, he keeps throwing, I mean, he literally just threw a tantrum because he can't pay attention to the slides and the guy talking at the same time. Are you seriously? I'm sorry, y'all. I'm gonna shut up because I got words and probably half of y'all are yelling at me right now and I'm not looking at my phone, but I mean, we don't have to like her and we can think he's guilty as sin, but she's not wrong. He put it out there. The fact that dude just popped his face up on the screen. I'm not gonna lie to you. I took a potty break and so I didn't have my phone, but I heard him start talking and I was like, no. He did.
He literally objects to the whole daggone slideshow. And
he don't want the PowerPoint because the PowerPoint's got the video in it.
Right.
I'm just saying, like he's slimy. I can't stand him. And I'm not saying it don't have nothing to do with Brian Kohlberger. Nothing. He's yelling and screaming and throwing down like a little baby because he knows that his face is about to pop up on that screen, disseminating the information that he's saying they put out there.
Right. It's pretty funny.
Anyway, sorry. I'm sorry. I'm sorry. I'm sorry.
No.
I'm gonna
Let's go. Let's keep on watching because this is gonna get even juicier, I'm sure.
Let me preface, there is a pending case now in court, and I and my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you through the court process or otherwise whatever we are allowed to. I just appreciate your patience on that. The factual basis for the charges are summarized in what's called a probable cause affidavit that is on file with the court. According to the rules of the Idaho Supreme Court, that is sealed until Mr. Kohlberger is physically back in Latah County and has been served with the Idaho arrest warrant. At that time, we expect that that affidavit will be available to you so you can share the true facts with all of your readers and your watchers and your listeners and all the people who are interested and really need to know what's going on. So please have patience with us on that. We hope to get that to you as soon as we can.
In that clip, you heard reference to the probable cause affidavit.
Yes.
And did you hear reference to sharing it with all your readers and watchers?
Readers, watchers, and listeners, and anyone else who's interested.
Did your research tell you that the media took Mr. Thompson up on that offer to share this far and wide?
Yes.
Good afternoon, folks.
What did you say?
Basically, the media took that document and then published the highlights and key findings in that document and added editorial commentary to that information. So let's be clear, they didn't just read the affidavit. There's editorial, there's debate, there's discussion, there's spin, all of it in news stories. And these stories, for example, this one has over 200, I'm sorry, I can't see it. Do you have a copy of the?
I do, Your Honor, I have a printed copy of his PowerPoint. If it would help him refresh his memory.
I just can't see it.
Sure, just go ahead.
Okay, thank you. So example, this one is on a local television station. On YouTube alone, 130,000 views and 224 comments. So people discussing it. That's just one example of how this document was disseminated through the media in this county, just as Mr. Thompson suggested during his press conference.
And did you check another media source and see that it continued to be shared?
Yes, this is a second example. And you can see just from the heading, it says court records unsealed. And then they go through a timeline, including information from that affidavit, highlighting all the key findings about the car and other things that are widely reported and disseminated from that document. To Latah County, saturating the community with prejudicial details from that document, which was reported in the press conference to be truthful as well. 54,000 views, 176 comments on just one other video of a news clip on YouTube.
And based on your research, did the story or stories continue to be shared far and wide?
Yes.
If Janelle Finch is joining.
Cases received massive media coverage, saturating this county with prejudicial pretrial rules.
How about to social media?
It was also spread through social media, and people have talked about it on social media.
And do you know if misinformation and rumors ended up as a result of this information shared right from the start?
Yes, and the reason I looked at this and knew it was because in the media coverage, they discussed the spreading of rumors on social media. For example, a professor who was accused by a psychic of being responsible for this. Other references to questioning the implication of people knew about the crime before it was reported to the police and so on. So there's been quite a bit of discussion, spread of rumors, misinformation, factual information all over social media, which you'd expect in a small community such as this.
Did your review of all of this information tell you as a professional, as an expert in your field, that a survey was necessary in Brian Koberger's case?
Yes, based off of the media coverage that I reviewed, which was over 200 plus articles, and the television coverage, I thought it was appropriate to move forward to see what impact, if any, this coverage has had on the community.
What kind of survey did you think would be appropriate?
We always use random digit dial telephone surveys in these cases.
Before you tell me a little bit more about that, I want to understand the history of this kind of survey. Is this something that you just made up all on your own?
No.
Where does this come from?
So these surveys have been done for decades. The first one I recall that followed a similar design and focus on case-specific items was done in 1979. Constantini and King in 3 cases in Yolo County, California. This approach was done, Dr. Ed Bronson, who I mentioned, my mentor, has been using it for decades, 40 years or more. Other experts in the field do it. John Walker, in the American Taliban case, they used a similar approach that was published as well. Used in Skilling, Boston Marathon. I've used it in countless cases, so hundreds of times, I would say.
Is there research that supports this process?
There is. One of the things we're looking at, so when you think about the survey, is the structure and how we test validity. So there's 40 plus years of social science literature on the impact of media coverage on juror and jury decision making. And one of the things it tells us, for example, is knowledge. Or let's take a step back. People who regularly watch and listen to the news are more likely to know about the case. When I say know about the case, are more likely to have case-specific information from the media. So they test similar things like we did. Have you read, seen, or heard if ... And they assess how much knowledge does this person have, and then they correlate it with media consumption habits. And what you find is people that read the news regularly know more of these details than people who do not. And they find that the more information you have, the more likely you are to hold an opinion regarding the defendant's guilt or innocence. So those are some of the findings, and we craft the survey similar to the others because we want to test the validity of the survey. So if we know we should see these relationships, we should expect to see them in our survey. So we ask the same similar types of questions, and we look at those relationships to see if we see the same thing. That's one of the ways we test the validity of the survey.
Would this be considered a methodology in your field to do surveys in this certain format?
Yes, it's standard practice. We look at APOR, which is called the American Association of Public Opinion Research, American Society of Trial Consultants. They have professional code on how to conduct surveys, venue surveys. Those are the primary ones I look at. And again, I've taken course training during my program on how to craft surveys, how to write questions, all of that type of thing. I've done it hundreds of times, testified about it. So that's kind of the basis of how I craft this.
And I heard you mention standards and validity.
Mm-hmm.
Why are there standards? Why does that matter?
I'm sorry, why are there standards?
Yes.
Well, one is you want to make sure, as we learn more about research in human behavior, we learn more about what you should and shouldn't do. So for example, there's something called social desirability. People want to create a positive impression of themselves. So when you ask questions, for example, can you be a fair juror? Well, we all want to be fair people, so you're more likely to get a socially desirable response. The initial step on that was all the way back into voting. In California, there was an election for governor, I think it's Davis or something like that, and all of the polling suggested he was going to win. He was African American, and he lost. And that was when they started looking at that, and they saw all these different impacts in terms of like race of the interviewer. All these things affect how people respond. People overestimate that they vote because you can look at voting records and it's inflated. overestimate they have a library card and a million other things. So those are things like we look at when we craft the survey. We don't want to have social questions that lead to socially desirable responses, order effects, a host of other things.
In your survey, it looks like you have sections designed in your survey.
Mm-hmm.
Sorry, can you hear me? Okay.
Better with the microphone.
Okay, I'll try to stand closer over here. I want to understand this section, these sections. Why do you have sections in this survey?
Sections?
Yes.
Well, one is you don't want things to be jumping back and forth all over the place because it's harder to take a survey like that. You'll have more people drop off, confusion, potential order effects. So we try to organize the survey into sections. So all the key questions on one topic are together, and then the next section changes topics, so it's easier to follow.
What is the purpose of section 3, case awareness and prejudgment? Why is that in there?
So that's the meat of the survey. That's the most important section. So case awareness measures initially case recognition. We craft a recognition question based off of the media coverage. What are the things widely reported that are not overly prejudicial because you don't want to create an order that would stimulate a memory of, yes, I remember that case. So if widely reported A, B, and C facts that you read the coverage and you see this was mentioned 100 times, that's a widely reported fact. So we create case recognition question. Now, if somebody says, yes, I remember that case, I have read, seen, or heard about it, they're asked a prejudgment question next, guilt or innocence question. Then they're asked open-ended questions and then those case-specific items. Now, let's say someone does not remember the case based on the case recognition question. We give them one more fact to see if it'll stimulate a memory. Something neutral that might stimulate a memory. You usually get 1 to 2% more that recall the case from that. If that person recognizes the case from there, they are also asked that prejudgment question and they continue. If they do not recognize the case, they skip the rest of the survey and they're asked demographic questions about media consumption habits and demographics. The next step of the survey after the prejudgment question is an open-ended question. What have you read, seen, or heard about the case? There might be a few others we add based off of these things we might find in the media coverage. And then they continue on to those case-specific items that we've been talking about. Have you read, seen, or heard if so and so?
I want to make sure I understand this and that this is clear for everybody. Those 9 questions that have been the problem last week and this week, if you have somebody who says, no, I don't know that case, do you ask them those 9 questions?
No, they skip to the demographic questions.
Tell me, what are the demographic questions, just to be sure?
If somebody doesn't recognize the case, they immediately go to questions, for example, how often do you read the newspaper? Every day, several times a week, rarely, never, something like that. Then they're asked how often they follow the local news, and then they'll ask a few demographic questions like age, gender, race, ethnicity.
So if somebody doesn't remember the case, you don't infuse information or do any of the things that were brought out last week.
No.
I have on the screen in front of me some of the read, seen, or heard questions.
Yes.
What are these? You don't have to read them all, just tell me what they are.
These are 9 items, which we always use. Have you read, seen, or heard if? And these are items taken from the media coverage that were widely reported. And let me be clear, widely reported hundreds and thousands of times, and potentially prejudicial items. Because neutral run-of-the-mill media coverage is often not grounds for a change of venue. So if somebody knew there were 4 victims, that's not particularly prejudicial, is it? That's a pretty benign fact. But if somebody knows, for example, about a prior conviction that's not admissible, that's very prejudicial. And it might be correlated with prejudgment. And I would like to know that, because if it's widely prejudicial and everybody knows about it, and it's correlated with prejudgment, that would likely have an impact on my recommendations, because that's the type of pre-trial publicity that has been recognized by the Supreme Court, I'm sure the state court here, that is most concerning.
So these kinds of questions, these case-specific questions, you do this in all the surveys that you do.
Yes.
And in this case, these 9 questions came straight out of the media.
Absolutely. And again, widely reported throughout the media, thousands of times.
Now, just to be clear, you gave an example of information that might be widely reported that's highly prejudicial that you would use in a survey. You haven't talked about Brian Koberger's survey yet, have you?
What do
You haven't told us the 9 questions.
I have not.
Okay. And we'll get there, but I want to talk about a little bit more about the history of this survey. You told us it had been used for decades. And I think you told us a little bit about some of the other really high profile cases where this survey format, the survey method that's been widely accepted was used. Are some of these cases your cases that you've done these surveys in on this list?
Yes, I used these types of questions in the George Floyd case for Alexander King, who was one of the defendants. There was also a gag order or non-dissemination order in that case. The Parkland shooting case in Florida, there was a non-dissemination order in that case. Used there as well. Used it in the Pittsburgh synagogue shooting case in Pittsburgh. State of Idaho v. Jonathan Renfro, which was here. State of Idaho v. Gilberto Rodriguez, also used it there. And many others. I've used it 100 times. Dr. Bronson used it more than me because he was doing it even longer than I have. Other experts in the field do it. This is the standard practice.
Standard in your field.
Yes.
And are these surveys, doing a survey like this, is this just criminal defendants that ask you to do these surveys or that have any interest in doing these surveys, or is it other people too?
Other people use the same process as well, including the prosecution and the government.
I think you provided an example in your PowerPoint of the government using this survey process in a case that you worked on.
Yes, this was the Jason Van Dyke case in Chicago. He had been charged with shooting and killing Laquan McDonald. It was like 17 shots was like the famous saying. It was a very significant case, interracial crime, widely reported on. And the government also did their own survey to see if there was any potential bias and followed the same exact process and used case-specific media items. And once again, there was a non-dissemination order in that case as well.
Earlier, you talked a little bit about validity being one of the standards.
Yes.
Tell me how you measure validity in one of these surveys.
Sure. So this is from the professional code from the American Society of Trial Consultants. As I mentioned, we want to look at things like consistency. So we want to, for example, the research tells us the more case or media items you know, you develop knowledge. And the more you know, the more likely you are to exhibit bias. So I want to test that in the survey. That's one of the reasons why I include those case-specific items. I also want to compare what people or that item to prejudgment. So the more people know, are they more likely to prejudge? How about case-specific media items? Is there specific prejudicial items in the media that are particularly concerning? Maybe I'm going to go back to my prior conviction example. If there was a conviction, because I've had this happen in your case, and then years later, that conviction was thrown out and there's a new trial. Well, that's extremely prejudicial if people know about the prior jury verdict. So I want to know, what percentage of people know that detail? And is that related to prejudgment? And most importantly, when you ask the question, have you read, seen, or heard about the case, the open-ended question, do people report it? Because if they don't, and they do know it, well, that's very concerning. And that's the type of problem we run into in voir dire.
Sounds like that's one of the reasons you have case-specific questions in there.
That's one of the reasons, absolutely.
You heard talk last week, and then you heard it again today about, can't you just change this survey and take those case-specific questions out and then do the survey? Can you do that?
I would not do that, no.
Can you explain why not?
Because this is based off of 15 years of doing this. I know for certain, and there's research on it as well, that when you ask people an open-ended question, what have you read, seen, or heard about the case? They have a difficult time recalling everything from memory. That's a recall question. The cognitive effort required to recall everything from memory that you know is very challenging versus recognition, which is a much lower cognitive load. have you read, seen, or heard if? Oh, now I can search my memory. Yes, I know that fact. If I asked you, tell me everything you know about the movie Star Wars, you would tell me a whole bunch of interesting things about Chewbacca and Ewoks, and maybe a bunch of other stuff. But I am very confident that you would miss things. You would not tell me every single detail from memory you know about that movie. And then I would ask you something like, did you know that Darth Vader was Luke Skywalker's father? And you'd probably say, yeah, of course, I knew that. But you didn't mention it in the recall question. There's a mountain of research on this. Usually what they do is they have people read like a paragraph or a story, and they ask them, write down everything you recall from what you just read. And then they do a different type of quiz. Did you read that the truck was red? Did you read that there was an ambulance? Oh yeah, of course. And they check that too. And what it shows is recognition rates, the ability to recall information when asked a closed-ended question, is much higher than when you ask an open-ended question. So getting back to your comment or question, if I only ask, what do you know about this case? I know for a fact you'll get things like, well, I remember when it happened. There were 4 victims. There was a knife. I remember there's a delay. I just saw it in the media. Those are the things that people say. They've said it in this survey. They've said it in 100 surveys I've done prior. They've said it in voir dire when I look at transcripts. That's what you see. But when you ask those closed-ended questions, you discover that they know quite a bit more. And that's what I'm trying to look at. I need to know, what do people actually know? And is there information, prejudicial details that they don't mention that they do know when you ask the open-ended question?
And those details, the closed questions, the have you read, seen, or heard questions, are they important to determine if there's bias, that media coverage has created a prejudicial effect, and that there's bias?
Absolutely. If 80% of people are able to recognize a prejudicial detail, and I keep making up because I don't want to upset anyone here, like a prior conviction, if 80% know that detail, but only 3% mention it in the question, what have you read, seen, or heard about the case? That's a major problem. I need to know that because it's an extremely prejudicial fact. Things spread on social media, whether they're true or not, they still impact the jury. Very prejudicial. I need to know if they know that. And I know for a fact in this case that, for example, I'm not going to mention the detail, but for one of them, only 3% of people in this survey mentioned the detail when asked, what have you read, seen, or heard about this case? It was something spread on social media. But when you asked, have you read, seen, or heard of X, Y, and Z, 45% knew that fact. And that fact happened to be significantly related to prejudgment. People who knew it, over 80% of them think the defendant is guilty, compared to 57% who don't know the detail. So those are important findings. If I don't include those questions, I can't do any of those analyses. It makes it look like there's not that much of a problem here. People don't seem to know anything. They just say they remember reading it in the paper. I guess we don't have to move the case because they don't seem to know much. And that is misleading, inaccurate, and I would not do that.
Have you had a unique opportunity to kind of actually watch this in real time to see how it works?
I have.
Can you tell us about that?
Yes.
How did you get this unique opportunity first?
So I worked on a case that was called John Fight. This was a Catholic priest in Hidalgo County in Texas who had been charged with murdering a beauty queen. Now, the crime had happened in like the 1950s, and the trial happened in like 2018 or something like that. So all the witnesses were gone, and the defendant was obviously much older. But it was a case that was just weaved into the fabric of the community. It was so shocking. And during the hearing, after doing the survey, one of the things we did is we brought in community residents and did like a mock voir dire to prove this point, to demonstrate. And there was a bunch of things in that case that were particularly prejudicial. So we asked people, tell us what you've read, seen, or heard about the case. And they would tell us, oh, in college, I learned about this case. And I know A, B, and C. And we say, is that everything you remember? And they said, for example, here, I believe so. That's what this person said. Search their memory. Let's see. I believe so. That's it. And then we asked those case-specific questions that you clearly could never ask in voir dire because you'd be poisoning the well. And we asked, for example, did you know that John Fight gave a confession to a priest, confessed to the crime? Oh, yeah, I knew that. And once she said that, it stimulated her memory. Actually, he confessed twice. So now she knows that. The fact that she did not mention in the open-ended question, extremely prejudicial. The Supreme Court has recognized confessions to be very prejudicial for Doe v. Louisiana, and a bunch of others, and she knows about it. And then we ask, kind of again, is that everything you know? And she says yes, and then we give her another one. Did you know that he was involved in another case? He had actually been charged with attacking a woman in a different church. Oh yeah, yes, I do remember that. Once again, she knows a detail that she didn't mention. And we're saying, okay, and you didn't say that a few minutes ago, did you? No, that's the second one. And then we asked, having refreshed your memory, are there any other facts that you have read, seen, or heard that you haven't told the court? She's, I don't believe so. So it seems like that's all she knows. Then we tried again, and we mentioned that he had been transferred to another monastery. The Catholic Church was moving him around. And she knows that too. Oh yeah, I did do that. And we tried again. Did you know that local law enforcement were participating in a cover-up? That was part of the story. Yep, she knows that too. So this was an example of the difference between asking the open-ended question that you can ask in voir dire, what do you know about this case? What have you heard about this case? And you get an answer. Sometimes people say, I just recall when it happened. Sometimes you get more detail. But when you start asking those closed-ended questions, you uncover that actually they know quite a bit more. And that is the key point in a high-profile case. In the general case, it doesn't matter because there's no case-specific information. What we know is that specific attitudes predict behavior much more than general attitudes. So in a community like this, it's been saturated with media coverage that's prejudicial. We want to know what case-specific details they know, because that goes to bias, and are we able to ferret out that bias in jury selection? And that's why we include those questions in our survey.
I want to talk about Brian Koberger's case for just a minute.
Your Honor, again, I'm going to register the objection. This is going to deal with the actual issue of change of venue. It's premature. The state has not been afforded the opportunity to analyze much less respond to it. So to the extent the court wishes to allow this to continue, I just simply ask you to give it that reduced amount of weight, because the state is not in a position to respond to any of this.
Okay, thank you. But you'll have an opportunity to respond to any of this before I make a decision.
Not today, Judge. I'm sorry.
Hold on.
Yes, sir.
I'm not going to make a decision today.
Yes, sir.
I'm getting information.
Yes, sir.
And then I'm going to consider what you're going to provide, and then I'm going to make a decision.
My point again, Your Honor, is this goes to the issue of a change of venue, not whether or not the non-disclosure order was violated and what we should do about that. Two separate issues. The state is not prepared and will not be prepared to address a change of venue issue until an appropriate motion with supporting documentation and evidence provided, and we have a chance to respond to that, which I understand we'll be doing between now and sometime next month.
Exactly.
Thank you.
Go ahead.
Thank you. Dr. Edelman, you haven't finished analyzing the data in Mr. Koberger's case, have you?
No, the only thing I looked at was supposed to be on the question at hand, which is about these case-specific items, why they're in the survey, and which goes to whether we can continue the survey without them. That's the only thing I looked at, was addressing that specific question.
I'm not going to ask you what your opinion on change of venue is today.
I don't have one. Well, I do, but I'm not done analyzing the data.
Senate, I want you to be informed before we get there. So I do want to talk, though, about Brian Koberger's case, and if you've been able to determine if the survey was valid.
Yes, absolutely.
And how did you determine that the survey is valid?
Well, one of the things, as I mentioned, is looking at the social science research and do we find similar findings? And we did. So we also look, for example, do we have like acquiescence bias? What that means is people just saying yes to everything. So on those case-specific media items, one of the things you do is you include items that didn't receive as much media attention. That way, you want to make sure, and what you expect to see are items that get a lot of media attention. Everybody knows about them. So you see really high recognition rates, 80%, 90%, 60%. And then the items that didn't get as much attention, they're lower, 40% or less. So we want to see if there's variance across the questions, and we see that as well.
Does it help to do the recall questions and the recognition questions to understand whether you have a valid survey? Is that what you're telling me?
Yeah, well, So I meant that those are the case specific questions. Yeah, those media items. So we test validity by, are those correlated with prejudgment? Are they correlated with media consumption? So people who read more of the media, do they know more of these details than people who don't? The more details you know, are you more likely to be biased? All that stuff. But also, again, like I said, is you want to check to make sure there's variance across those media items, because you want to make sure people aren't just saying yes to everything.
You talked early on about how if somebody doesn't recognize a case, you stop and you don't ask these case-specific media generated items in your question.
Correct. And remember, these media items also come after the open-ended, what have you read, seen, or heard about the case?
Do you know how many people did not know about Brian Koberger's case in this survey? The percentage?
I believe it was like 3 to 4%.
And so that percentage of people didn't get the case-specific questions. Is that fair?
The people who did not know about the case, the very few, did not get the case-specific questions.
I want to talk about the open-ended questions and then the have you read, seen, or heard questions. On the open-ended questions, when you say, what do you know about this case? Tell me everything. Do you know about how many things people remember?
Yes, so one of the things we do is we read everyone and we track how many details they mentioned. And then we compare those, what did they say, to how many case-specific items they later recognize. So for example, if somebody said, I know 4 people were killed and they found the guy, I would identify like 2 facts, 2 details, for example. And then I would look at those case-specific items later and how many of those items did he mention in the open? And that scenario would be 0. But if he knew 6 of them, that would tell me that he knew 6 details that he failed to recognize. Versus somebody might have known all those details and mentioned all of them in their open, then it would be 0. They reported everything they knew, and they mentioned later on that they knew those items. So I look at that.
You're checking what they say they know in the general open question, and then see if they hit some of the specific questions, and then measuring how many more they actually know when you get to the have you read, seen, or heard question.
And then I compare. And that kind of goes to my John Fight story. I'm looking to see if that is a problem.
What did you find in this case?
I found that 96% of survey respondents knew at least one additional media item that they failed to mention in the open-ended question. On average, people reported 1.6 details when asked the question, what have you read, seen, or heard about the case? However, on average, they later recognized 6 out of the 9 media items, and I believe it's something like 72% knew, I want to say 5 or more.
Now, in this situation, did you find out people had a lot of knowledge that wasn't the specific case-related question? They would rattle off, I know these things, several things.
Yeah, so what I found was, on average, people knew at 4.9 additional items that they failed to mention in the open. What does that mean? That means they knew approximately 5 of the media items that I tested later that they did not mention in the open-ended. 5, on average, out of 9, they knew, although they didn't mention it. And these are examples. So somebody wrote just what has been on the TV and the papers. That's the common thing you get when you only ask the open-ended question. But that person knew all 9 of the media items we tested. Someone else mentioned the detail. The kids were murdered and they tracked them down. Well, you actually know 6 out of the 9 media items that we tested. Nothing lately knows 7 out of the 9 media items tested. And it goes on and on. That is a very common finding. I find it in almost every survey I do. Between 92 and 96% is the norm. What I see in terms of knowing more detail than they report. And it usually, interestingly, the average is usually around 3 extra media items that they failed to mention. In this case, it was 4.9, so it was higher.
Do you have a way within the survey to correlate prejudicial coverage or bias for guilt with the amount of specific details recognized?
Yes, because I asked those case-specific questions. If I didn't, I would not be able to, because as you saw, people say things like, haven't seen anything lately. Well, that doesn't really do much for me. I can't analyze that. I can't do anything with that. I don't ask those case-specific items. I can't test the validity of the survey. I can't test to see how case-specific knowledge impacts prejudgment. I can't test to see if there's one particular item that's highly prejudicial that we should be worried about, that should, that's inadmissible. What percentage knows that detail? All of those things are required to do this correctly.
And how do you know that there's prejudgment in a case? What questions do you ask, and when do you ask them to know that there's prejudgment or bias in a case?
Well, after the case recognition question, they're asked, based off of what you've read, seen, or heard about this case, do you believe the defendant's guilty of whatever the crime is? And it's on a scale of like definitely guilty to definitely not guilty. So that's a prejudgment question. I have a second follow-up question, which was actually developed from a judge that I thought was really effective. And the question was, would the defendant have a difficult time convincing you that he's not guilty? So it's a presumption of guilt as opposed to a presumption of innocence. This was in Tennessee. It was a high-profile case, and similarly, people would report a lot of detail, and then they'd say, "I think he's guilty," and then they'd ask, "Well, can you be fair and impartial?" And they go, "Yeah, I think I could be fair. I can try. I think I could do it." And then the court would ask, "Well, would the defendant have a difficult time convincing you that he's not guilty?" And they'd say, "Oh, yeah, definitely. It could be hard to change my mind." So I use that question because I thought it was really effective, and it happens to correlate much better than the set-aside question with prejudgment and a host of other things.
So do you ask those questions before you say, have you read, seen, or heard these particular?
Absolutely. If you didn't, you'd be creating order. So you have to do that.
Will you say that again? You'd be creating what?
Order effects. If I put in like a recognition question, some detail that's extraordinarily prejudicial, I'll go back to my prior conviction thing for the same crime. And then you say, "Oh, do you think he's guilty?" Well, you just told me a jury convicted him. Of course I think he's guilty. So if you included all those 9 items, and then you ask somebody, "Do you think he's guilty?" You just gave them all this information that's prejudicial. So yes, that would be an order. So we would never do that.
So you ask them well ahead of case-specific questions. They have to recognize the case. They have to agree, I know of this case. And then you ask if they already have an idea of what they think of whether Mr. Koberger is guilty or not in our case.
Correct.
And then you have the case recognition, and you can measure the bias or the prejudicial effect of the media with the incidence of those questions.
What I look at is the prejudgment question, right? That's on a scale, so Likert scale. And then I can look at things like, is a relationship between the number of details somebody knows and the strength of opinion? Definitely guilty, for example, if you know a lot of detail. I can look at case-specific items, media items. If you knew about X, is that correlated with prejudgment or bias? Is there something that, and so on and on. So that's how we look at the relationship between prejudgment and these different factors.
Were you able to determine if case knowledge was impacting bias in Brian Koberger's case?
Yes. So because we asked these questions, what we found is that one, like I said, very high recognition rate. So 79% of respondents knew at least 5 of these items. So the idea that we're undermining his due process rights, everybody knows all this stuff. Very high rates. 82% of respondents who recognized 7 of these items or more reported that he's guilty, compared to if they only knew 2 or fewer, only 29% thought he was guilty. And the average was 6.2. So the average number of these details people already know, 6.2.
Given specific case-related bits of information, these 9 have you read, seen, or heard questions, does recognizing one of those questions, if that's oh yeah, I know that one, does that change the incidence of bias, or does that relate to, I've already prejudged this case?
It does. And what's really interesting is kind of going back to the open-ended question. So again, I won't mention the detail, but there's one that was widely reported. It's in that affidavit. And 81% of survey respondents knew that specific detail. 81% when we asked, what have you read, seen, or heard about this case? However, on the previous question, what have you read, seen, or heard about this case, the open-ended, only 8% reported it. 8% report it when you ask the open-ended question. 81% actually know the detail when you ask a recognition question. That's significant, and I can only do that analysis because we asked those questions. And 72% of people who knew that detail reported that he is guilty, compared to just 47% who don't know the detail. So that's the kind of analysis we look at. What do these case-specific items look like? If you know this media item, is it correlated with guilt? What percentage of people know that media item? How many people mention it in the open? Is it consistent, or is it a perfect overlap, or nobody talks about it, but they all know it? In another one, only I think it was 3% mentioned a specific detail that was on social media, widely reported in the news, not factually accurate, a misrepresentation of the truth. 45% knew it in the survey. Only 3% reported it in the open-ended comment. And it was extraordinarily prejudicial, where if you did know it, 81% of survey respondents, if they knew that detail, indicated that the defendant was guilty. 81%, half the sample knew about it, but only 3% mentioned it when I asked the open-ended question. So again, if I didn't ask those questions, and the only thing I asked was the open-ended question, it would appear that people don't know a lot of prejudicial detail because they don't mention the detail when you ask that question. And that is, from my experience, doing post-conviction work, reading voir dire transcripts, coding transcripts, doing hundreds of jury selections, being involved in these cases, coding jury questionnaires. This is the phenomenon that we see all the time. It's nothing new. And the only way to look at it is by doing the surveys.
Before I ask the question about courts relying on surveys to make decisions, using these surveys to make decisions to change venue, when you talk about things that are in the media that aren't true or might not come in, we've heard a lot about that today. Are you telling me that that's still going to be in my courtroom? Things that aren't true, that don't get brought out in trial, those are still going to be in the jurors' minds?
Absolutely. And again, there's social science research on this, looking at the impact of inadmissible content, the effectiveness of judicial instructions, and how it impacts jury decision-making. Just because you say it's not evidence doesn't mean it's not prejudicial. Just if I know it, it impacts how I view the defendant. It serves as a filter through how I process information. I might expect to hear that information when I can assume that I will, so it has an impact. One interesting study looked at jurors' ability, or participants' ability to recall the source of information. And what they found is, after a few days after a trial, people couldn't recall what information they had learned from the media and what information they recalled and learned from the trial. So they assumed stuff in the media came out in trial. The idea that I can cognitively say, okay, I know this prejudicial detail, and I'm going.
All right, guys, I got a quick question. Is everybody okay with us finishing this tomorrow? Us finishing? QB?
Margaret, come back 1 year, ma'am. No survey and no soup and no poll for you.
Come back 1 year.
Come back 1 year. I'm fine with it.
Okay.
I know you're tired.
I am tired.
You've been on all day, and but I gotta tell y'all,
I'm yawning. Oh,
science works, y'all. It's amazing.
I mean, don't get me wrong. I understand the way the surveys work now. Now I'm like, okay.
Y'all don't listen to QB. Y'all just think I got my full hat on and I'm spewing.
I don't think that.
I know you don't. It's just, it's hard. It's a hard place to get to, and I still struggle, but you have to take your feelings out of it. Okay?
Yeah.
We're all angry. We all think he did it. I'm on the fence. I'm not going to lie, but I'm leaning more towards he did it. Okay? We're all angry. We all think he did it. We all want him to pay. Okay. So anytime anything comes up that from his side, no matter what it is, the sky is blue. No, it's not. Because we're angry and we want him to pay. I mean, it's human nature.
Right.
So, but but see, the thing is, Steph, is that every detail wasn't out there. Okay. The prosecutor is the one that read into public record the 9 questions that were asked. It wasn't out there. They had only done 400 people out of 40,000. They could have easily said, okay, if the judge says, hey, we're not going to do this, we disclude these 400 people and we change the survey, or we don't do the survey, or whatever, and we move on. The judge had seen it. He didn't have to say, but I'm saying, Steph, he's not the one that put it out there. The prosecutor put it out last week. He read everything into public record. He read all 9 questions.
Yeah, he kind of did.
Last week. I mean, he didn't I mean, I don't mean no offense. He didn't kinda. He
Yeah, I
stood
know.
there with
He
his
did.
chest puffed out and read them into the public record. And I'm sorry, but I think he did that on purpose because it biased her client. But now that you see how the surveys work and what they're used for, you see that there's no bias to put in there unless the bias already exists. If they don't know
Right.
about the case, they don't ask them.
Right.
You know, and so, but yeah, no, I agree with you, Steph. The survey does put it all out there, but he already put it all out there. So why not?
True.
I bet that judge is sitting there right now going, son of a crap, I'm going to have to let them do this survey.
Well, here's the thing. And I've said it from that very first hearing that we played on here. Though that judge,
I don't think he's as wishy-washy as y'all think he is.
I don't think he's wishy-washy. I think he just lets them run over top of him.
Well, it's kind of wishy-washy, ma'am.
No, wishy-washy to me
Wishy-washy. Yeah,
means
you're
goes
fair.
back and
That's fair.
forth.
You're
Back
fair.
and
You're
forth.
fair.
I'm just saying he does not. He lets them tell him what to do, and
I'll tell you what, if I was a judge and somebody stood up in my court and raised their voice like that man did earlier, I'd have been like, I'm gonna need you to tone that down a minute, or I'm gonna give you contempt.
Yep.
I don't know where you think you are right now, but we are in court. We are in session.
But it's not just him. It's not just that man.
Oh no, it's her
And
too.
Taylor does the same thing.
No, they both do. They both do.
He just sits there and he's like, well, I don't know what I should do.
Well, and I think,
mean, and then it's like his what do you call it? His plan ends
I
up
called it.
his plan ends up being with whatever sounds good in the moment and appeases everybody. And
Well, and so I'll say again what I said earlier about these people with Daybell. I don't know that he knows what to do, Jenny, because they haven't had anything like this. And they certainly haven't had a trial expert like Dr. Bull come in there and be like, well, here's the science and this is how it works and this is why it works. And now they're all gobsmacked. And even the prosecutor's like, well, dang, even I can't disagree with that. You know, like, so I don't know that he really knows. And so he's like, he's trying to be as impartial as he possibly can so that, why is that doing that? So it doesn't come back to bite him in the butt later. But in doing that, he's being completely impartial and just like, okay. But I mean, in this instance, Ann Taylor wasn't wrong. She was like, just why don't we stop talking about all this crap and just listen to the expert? It'll clear everything up. And it literally cleared everything up.
It's less about him being impartial and more about him just taking control of his courtroom for me.
Yeah, he needs to. Like, I wanted him to stand up and I mean, and if Ann Taylor would have done it, I would have said the same thing, that he needed to stand up and tell her to sit down because she forgot where she was.
Mm-hmm.
Don't raise your voice in my court. And I don't care if you're raising it at me, her, him, them, they, whoever. I don't
Mm-hmm.
care.
Mm-hmm.
Don't raise your voice in my court.
Yep.
Anytime
right. They start coming back and saying, but judge,
right.
but judge. No, no.
Yeah.
No.
I want to say, ma'am, I thought the same thing. And I ain't even interested, but boy, you give me some science. And I'm like, what do you look like? Where you
Yeah, I
at?
know. I kind of want to see what this dude looks like too. I was kind of imagining. I feel like he looks like some young college boy, but then again, he could be
He
some.
don't.
I don't know what he looks
He's
like.
been doing this 15 years and he has a PhD and all the other things. He ain't young.
Well, he sounds young.
I'm just saying.
Right, Steph. Yeah, they make
Yes.
vague accusations of misconduct and he gets scared. So I don't know. I know his name is Brian something because I was like,
Brian. Oh, not that Brian.
Yeah, I can't remember what they said his last name was. It was something weird. But I don't know. I just feel like the judge. I don't care if he's impartial or not. I don't.
No,
I
I
don't.
agree. I don't disagree with you, Jenny. I don't disagree with you. I feel like I'm disagreeing with everybody today.
No, it's not that I feel like you disagree. That's not it. I just mean.
I agree. You need to take hold of it. And just the fact that, initially, like today, the prosecutor stood up and he's like, oh, well, I'm not blaming Miss Taylor of impropriety. But last week, he started out with, and in his motion, it said that she was inappropriate. And then the judge said, well, if anybody's inappropriate, it's the guy that she hired. I mean, it's by proxy, but it's not technically her. And so then the prosecutor was like, oh, the judge doesn't agree with me. Let me change my tune. Okay. I don't like him. I don't like her either. She gets on my nerves, but she ain't wrong.
I like to listen to the prosecutor. I think it was Henny in here earlier called him Santa Claus.
You just like his voice.
I do.
Like
but I mean, I kind of like his attitude too. I mean, I like I like his attitude, but at the same time,
what I don't like,
that's
I like
one thing
attitude.
That's one thing when he's talking to a witness or to the defense or to someone else, but not to the judge. And second of all, if they're going to end up if the judge don't take control now, which it's beyond me, he ain't going to. If he was going to, he would have done it from the beginning. So I'm just thinking, if you ain't got control of these two now, you're definitely not going to have control of them when they're in the trial.
I'm gonna predict right now that at some point this judge is gonna go, now look, you two, I have let y'all ramrod through here and try to figure it out on your own, and I'm pulling this car around and I'm turning around and we're going back to the way that it was, and y'all need to sit down and be quiet and behave yourselves in my courtroom. I'm calling it right now.
Well, and you know what? If he does, I will.
Can we stand up and applaud him?
That's it. Brian Edelman.
Yeah,
I will stand up and applaud him. But what's going to happen if he don't get control of these two and in control of that courtroom? He's going to let them run him over, and then something is going to come up for an appeal.
Yep.
And that's not good.
That's not good.
So.
That's not good.
But so tomorrow we will finish this during a break. Who knows how long this thing goes? I don't know. I mean, I don't feel like that Brian Edelman dude is going to hush anytime soon. And second of all, I want to do that, and I want to do the thing we were going to do earlier, the Chad's blessing, patriarchal blessing.
Oh yeah, I didn't mean to interrupt that.
Yeah, we can do that tomorrow as well. but I'm
Well,
ready
and
to
he's
call
not going to make,
it hard.
and he's not going to make a decision on this.
Mm-mm.
So it's not like we're going to have a spoiler.
No. No, but I would like to see them argue. And I hope that the judge does take control tonight and is like, that's it. Order in my court now. Or so help me.
I'm
so
waiting for,
help
I'm
me.
telling you, I'm waiting for it. He reminds me of my ex-husband.
Yeah.
Switzerland
judge?
until he ain't. Yeah.
The way he
That
looks
judge,
or the way he acts?
no, the way he's acting. The judge in the suitcase, not Sarah, the little boy in the suitcase. That judge reminds me of my ex-husband. You know, my ex-husband was a judge, right?
Mm-mm.
Yeah. Yeah.
No, I did not.
He held night court.
Oh, he was a Harry.
He was a Harry. Yep.
Oh.
Yep. You know Michael Peterson, the staircase
Yeah.
murders? Okay. He did all the warrants and all that for Michael Peterson.
Oh.
I saw all the autopsy photos.
Ooh.
Yeah, I used to go to court with him. Night court.
Kel said he was a Harry judge.
Yep. Yep.
Sorry.
Yep.
Yeah.
Anyways, he's fine. He's fine. He's fine. He's an ex because of circumstantial evidence. Circumstantial, not evidence. Circumstantial circumstances.
Gail, what was a Toy Story reference? Gail said Toy Story reference. I don't know what.
Oh no, that's what I was leading to, Steph, was that they're not going to come to a decision. So we actually could watch this on Friday.
Yeah.
But I don't know. Anyways, go. I'm going to go down because otherwise I won't let you say your Southern goodbye.
Oh, yeah. Oh, okay. Or so help me. Yeah. Okay.
All right, love you, mean it. I'll see you in the morning. Bye.
Love you, mean it. Thank you for joining today. And she's gone. Yay, Margaret. I'm glad that your headache is gone. All right, you guys, I'm going to get out of here and go eat some dinner and go talk to the husband and all the things. So it is almost 9 p.m. So I'm going to get. But I will see you guys back in the morning, 10:30 Eastern Standard Time, maybe a few minutes before, just so we can chat for a few minutes before they get started. So make sure to thumbs up and subscribe if you're new, ring the bell, and all the things. And thanks for hanging out with us all day today. Kel, thank you for coming up too. And maybe Friday will be a good day for you to pop in, like, throughout the day. Tomorrow, lunchtime maybe. I think they said lunchtime was at noon. That's 2 Eastern, so that's what, 11 for you? Yeah, all the YouTubey things. And thank you, Steph, for coming up earlier today too, ma'am. I love y'all, and I'll see you tomorrow. Bye.